David, are you getting pretty familiar with the voices and the names?
I'm getting better every time we do it.
Yeah. Yeah. I mean, I guess, yeah, don't be afraid to speak up, you know, if you're not sure.
All right, Judge. Thank you.
And, you know, you don't, I know that, but just want to encourage you.
I appreciate that.
Mr. Hearing Examiner. All the connections are done.
Okay, great. Thank you, Anna. Okay, I'm going to mute till we get a little closer to the start time.
All right.
Good morning. We have quite a few people that are trying to join as Carrie Salas. They're in the waiting room. We're trying to get our system set up here for the joint applicants.
I'm a witness and an attorney.
We have a witness and an attorney. They may be under CJ Salas or Carrie Salas. We'll be changing the names to joint applicants witness. So if we can let them in, please.
Well, Carrie Salas, excuse me, is not an attorney.
No. I'm sorry, Mr. Schanhauer. The Zoom profile name was inadvertently set. Once we are in the meeting, we will change it. But it's just our computers here.
Okay, so I'm talking to joint applicant's attorney right now.
No, my name is Adam Alvarez. I'm just the technical support guy. I'm helping with this, getting the computer hooked up to Zoom.
So how are you planning to do it? You're going to have one connection for the attorney and one connection for the witness. Is that it?
Yes, that's correct.
Okay.
Hi, Carrie Salas.
And Carrie, your name is going to be the one that's on the witness link.
It will until we sign in, and then we'll change the name. It's just, I think we might be coming up twice as either joint applicant attorney or maybe my name. We'll fix it as soon as we get in there. We're like in the waiting room on the other computer, and we're thinking that's why we haven't got able to be let in.
Okay, well, we'll try it again. Try it again for
Okay.
under your name, Carrie.
Okay. All right. Adam's trying it again. Sorry about this, Ashley.
Yeah, I was listening.
Okay, there you are.
Do I mute the audio on this?
Yeah, you can sign off on that one. And let me come to participants. Mr. Shannon, can you hear us?
Yes.
Okay, sounds good. Thank you.
Mhm.
Mr. Shannon, we also have another Zoom participant named PNM attorney that's trying to get in. That is one of our attorneys. Mr. Shannon, I don't know if you're available. We do have one other Zoom participant titled PNM attorney that's in the waiting room.
All right, everyone. Good morning. Can you hear me?
Yes,
Mr.
sir.
Examiner,
Yes, Your Honor.
Good. That's always a good start. Good morning, everyone. David, are you ready to begin?
yes, sir. Yes, sir.
Okay, let's start then. Okay, good morning. This is the case entitled "In the Matter of the Joint Application of Avangrid Inc., Avangrid Networks Inc., NM Green Holdings Inc., Public Service Company of New Mexico, and PNM Resources Inc., approval of the merger of NM Green Holdings Inc. with PNM Resources Inc., approval of a general diversification plan, and all other authorizations and approvals required to consummate and implement this transaction. The joint applicants are Avangrid Inc., Avangrid Networks Inc., NM Green Holdings Inc., Public Service Company of New Mexico, and PNM Resources Inc. And I understand that during the course of this litigation, Iberdrola SA has agreed to become a joint applicant. And the case number is 20-00222-UT. Good morning. My name is Ashley Schenauer. I've been designated to be the hearing examiner in this case. And I'd like to start today with appearances of counsel. So let's start with joint applicants.
Mr. Hearing Examiner, Brian Haverly and Kurt Weil on behalf of Avangrid Inc., Avangrid Networks Inc., New Mexico Green Holdings Inc., and Iberdrola SA.
Morning. And then the PNM side.
Yes, good morning, Mr. Schanauer and others, Rick Alvidres and Stacy Goodwin on behalf of joint applicants PNM and PNM Resources.
Okay, good morning. CCAE.
Good morning, Stephanie Zur on behalf of Coalition for Clean Affordable Energy.
Okay, WRA.
Sydney Beatles for Western Resource Advocates, and Steve Michael is also appearing for them. And when you get to preliminary matters, we will have one item. Good morning.
Good morning. Okay, the Attorney General.
Good morning, Mr. Hearing Examiner.
There you
Gideon
are.
Elliott for the Attorney General's Office. I'll also be joined by Kevin Gedko and Choya Corey.
Okay, good morning. Interwest Energy Alliance.
Good morning. This is Joan Drake on behalf of Interwest Energy Alliance.
Good morning. New Energy Economy.
Good morning, all. Marielle Nanasi and Tim Davis on behalf of New Energy Economy.
Okay, NM area.
Good morning, Mr. Hearing Examiner and colleagues, Peter Gould and Kelly Gould for NM area.
Good morning. Sierra Club.
Jason Marks appearing this morning for the Sierra Club.
Okay. Morning. Albuquerque, Bernalillo County Water Utility Authority.
Good morning, Your Honor. Nan Winter with Stelzner, Winter, Warburton, Flores, and Dawes in Albuquerque for the Water Authority. We will also have Dal Harris and Keith Herman joining us periodically over the next couple of weeks.
Okay, good morning. City of Albuquerque.
Good morning, Mr. Schnauer. Jane Yui on behalf of the City of Albuquerque. Good morning, parties.
Bernalillo County.
Good morning, Mr. Hearing Examiner. Jeff Albright, J. Albright Law LLC, representing Bernalillo County. And I also will have a couple of preliminary matters once we begin.
Okay, Westmoreland Mining. County of Los Alamos and MSR Public Power Agency.
Good morning, Richard Virtue on behalf of Los Alamos County and MSR Public Power Agency. Daniel Najjar of my firm may also be appearing from time to time when I'm unavailable.
Good morning. And then we have a number of parties that we've been identifying or referring to as community groups.
Yes, good morning, Mr. Schnauer. Kyle Tisdale, representing community groups. Those groups are Dene Citizens Against Ruining Our Environment, Toe Nashoniane, NEVA Education Project, and San Juan Citizens Alliance. And I'll be joined periodically by co-counsel Allie Beasley during the course of the hearing. Thank you.
Good morning. City of Farmington.
This is Randy Bartel on behalf of the City of Farmington, also Enchant Energy, and also Walmart, Inc.
Good morning. International Brotherhood of Electrical Workers, Local 611.
Good morning, Mr. Hearing Examiner. Justin Lesky on behalf of IBEW Local 611.
Okay, good morning. Onward Energy Holdings.
Good morning, Your Honor. Joseph Yar on behalf of Onward Energy Holdings, LLC.
Kroger.
Good morning, Your Honor. Kurt Boehm appearing on behalf of the Kroger Company, and I will have one preliminary matter once we get started. Thank you.
Good morning, staff.
Good morning, Mr. Hearing Examiner. Bradford Borman appearing on behalf of Utility Division staff.
Okay, good morning. Have I missed anyone? Okay. Sounds good. Okay.
I just texted.
As I indicated in our pre-hearing conferences, I'm going to start off with the admission of a number of commission exhibits. I provided notice that I intended to offer those into evidence in several pre-hearing orders, and I gave deadlines for parties to file any objections they had to those, and didn't receive any objections. So I'm going to admit 10 of these exhibits. And for the record, I'll just read the names, the titles into the record. Okay, Commission Exhibit 1, we're going to take administrative notice of that. That exhibit is located in the Commission's e-docket files. And that exhibit is titled Joint Applicants Responses to Bench Request Number 1, including text to response to request number 2, the unanimous stipulation and agreement entered in docket number 51547, on March 30, 2021, before the Public Utility Commission of Texas, and purchase and sale agreement between the Navajo Transitional Energy Company, LLC, and Public Service Company of New Mexico, dated November 1, 2020. Commission Exhibit 2 it consists of the balance sheets, including Exhibits A, B, and the redacted version of C from joint applicants' response to bench request number 2. Commission Exhibit 3 consists of the unredacted AGR consolidated GAAP balance sheet filed with the July 9, 2021 joint applicants filing pursuant to July 6, 2021 order denying joint applicants April 22, 2021 request for confidentiality pursuant to paragraph K2 of the protective order and limited request for reconsideration. Commission Exhibit 4 consists of the New York Stock Exchange Rules 303A.01 Independent Directors, 303A.02 Independence Tests, 303A.03 Executive Sessions, 303A.04 Nominating/Corporate Governance Committee, 303A.05 Compensation Committee, 303A.06 Audit Committee, and 303A.07 Audit Committee Additional Requirements. Commission Exhibit 5 consists of an excerpt from the Avangrid Inc. 10-K for 2020, pages 34 through 35, and that includes risk factors relating to ownership of our common stock. That's the section that's included. Commission number 6, again, administrative notice. This is a large document. It's included in the Commission's e-docket files. It consists of joint applicants' response to order regarding Avangrid service quality issues and management audits filed May 18, 2021. Commission Exhibit number 7 is JA Confidential Exhibit July 27 SUP SUPP PAB-question 6 attached to July 27, 2021 supplemental testimony of Pedro Azagra Blasquez, the Spanish version. When I prepared the Commission's list of exhibits, I indicated that the confidential status was still to be determined. It has now been determined not to be confidential by the order that I issued yesterday. Commission Exhibit 8 is JA Confidential Exhibit July 27 SUP PAB-question 6 attached to July 27, 2021 supplemental testimony of Pedro Azagra Blasquez. This is the translated version of that exhibit, translated into English. And I indicated in the Commission's exhibit list that the confidential status was still to be determined, and that has been determined as of yesterday to be not confidential. Commission Exhibit 9 is under seal. It's titled JA Confidential Exhibit July 27 SUP PAB-question 12A, 12B, 12D, and 12E, tribunal only, attached to July 27, 2021 supplemental testimony of Pedro Azagra Blasquez, Spanish version. And that has a confidential access restricted to the hearing examiner, commissioners, commissioner assistants, Office of General Counsel, and Commission advisory staff. Commission Exhibit number 10, also under seal, JA Confidential Exhibit July 27 SUP PAB-question 12A, 12B, 12D, and 12E, tribunal only, attached to July 27, 2021 supplemental testimony of Pedro Azagra Blasquez. This is the translated version into English. And again, this version, this exhibit is deemed confidential with access restricted to the hearing examiner, commissioners, commissioner assistants, Office of General Counsel, and Commission advisory staff. Those 10 exhibits, Commission exhibits 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 are admitted into the record. Before we get to other parties' preliminary matters, I have one additional matter. On Friday, the City of Farmington and Enchant Energy filed a notice of withdrawal of the testimony of Hank Adair. Under the Commission's rules, testimony that's been filed with the Commission needs to be withdrawn through a motion. And so I'm considering that filing to be a motion, and I'm asking if there are any objections to that motion. Okay, hearing no objections, the City of Farmington and Enchant Energy's notice of withdrawal of Mr. Adair's testimony is granted, and he will not be required to testify in this case. His testimony will not be admitted. And I would also, I guess, like to take this opportunity to deal with a number of witnesses' testimonies for whom no party has requested cross-examination time. And we'll be asking the parties to stipulate to the admission of that testimony and to excuse those witnesses unless there's any objection. The first testimony is the community group exhibit number 1, the April 2 direct testimony of Adela Begay, Bejgaye. Is there any objection to the stipulation into the record of her testimony and her excusal from appearing in this hearing?
No, sir.
Okay, hearing none. Her testimony is stipulated into the record and she's excused from testifying, from appearing here. The second one is Joseph Hernandez. His testimony is identified as Community Group Exhibit 8, which has filed, had an attached exhibit, which is now appears to be offered into evidence as Community Group Exhibit 9. It's his April 2 testimony. Is there any objection to the stipulation into the record, the admission into the record of his testimony and the excusal of his appearance in this case? Okay, that testimony is admitted and he will not be required to appear. Next one is Jessica Keetso, Keetso. Her testimony has been identified as April 2 testimony, identified as Community Group Exhibit 10. Is there any objection to the admission into the record of her testimony and the excusal of her appearance in this case? Okay, hearing no objection, Ms. Keetso's testimony, Community Group Exhibit 10 is admitted and she is not required to appear. The last one is Jeff Spurgeon, Spurgeon. His direct testimony filed in support of the stipulation. It's been identified as Onward Exhibit 1. There's been no cross-examination identified for him. Is there any objection to the admission of Onward Exhibit 1 and the excusal of his appearance in this hearing? Okay, hearing no objection, Mr. Spurgeon's testimony is admitted as Onward Exhibit 1 and he will not be required to appear. Okay, that deals with my preliminary issues. I guess I've heard that other parties have some. Who wants to go first?
Western Resource Advocates will go first.
Who said that?
Sydney Beatles for Western Resource Advocates, but Steve Michael will cover this item.
Good morning, Mr. Hearing Examiner. Consistent with your June 21st order, granting the joint motion to take administrative notice of climate change, its causes, and its likely consequences, we'd ask to have Exhibit WRA-1 admitted into the record, and that exhibit consists of the order I just referenced, as well as the underlying motion that was granted.
Okay, is that included in the list of exhibits that you put on?
It is, Mr. Shanauer. It's WRA Exhibit 1.
Okay. Is there any objection to that? Okay, WRA Exhibit 1 is admitted.
Thank you.
You're welcome. Okay, next.
Your Honor, this is Kurt Bain with the Kroger Company. And I filed a motion on Friday to be excused from the hearing. We didn't file testimony, and I don't have cross-examination for any of the parties.
Is there any objection to Mr. Bain's request? Hearing none, that request is granted.
Thank you.
Welcome. Okay, is there any more?
Hearing Examiner?
Yes.
Yes, Jeff Albright for Bernalillo County. Just a couple of administrative issues. I have potential commitment on August 16th in District Court, Sandoval County District Court, and may be absent for a short period of time. So once again, in my absence, certainly agree to abide by all decisions and objections and any findings or rulings by the hearing examiner and the other parties with your permission. And I may periodically be absent throughout the course of 2 weeks, but I'm going to obviously try to minimize that. That's the first item. Second item is that about 8 o'clock this morning, I lost I lost server to my email address. Up until then, it looked like it was working. I was able to get a server for the internet, and hence I'm here on the Zoom meeting. I don't know, people are looking at it internally. My IT group is located here in the building. I don't know if that's going to be periodic interruption at some point in time in order to fix that or to ensure that I continue to have the Zoom access. But I did want to alert the hearing examiner and my colleagues that that may be an issue if they're trying to reach me. Have determined that it is at this end. The server folks tried to reach me and could not. So that was about as of 8 o'clock this morning when that happened. So I do have a cell phone available if you need to text me or reach me. It's 505-967-5902. So I make that available. Those were the only two issues that I had for the commission at this point, or for the hearing examiner at this point.
Okay, anyone else?
Mr. Hearing Examiner, this is Joan Drake with Interwest. Likewise, I don't have internet issues this morning, thankfully, but like Mr. Albright, I may have to be absent from the hearing from time to time. So I would ask to be excused during those times that I can't appear. And of course, I would abide by any rulings of the hearing examiner during the times that I'm absent, and I will be here to present our witness.
Yes, that is, of course, the general rule. If someone's not here while the proceedings are going on and things are decided while they're not here, they waive any objections they have to those things that have been decided. So I think we all understand that. Is there anything else?
Yeah, Mr. Hearing Examiner Richard Virtue, I have the same request as Mr. Albright and Ms. Drake. I may be absent from time to time, and it will be with the understanding that you just stated. And I don't have any cross, and I will waive any objections or other rulings that occur while I'm absent.
Okay. Anyone else?
Mr. Hearing Examiner, Kyle Tisdale on behalf of community groups, simply to add on to the chain of my colleagues here. Either myself or Allie Beasley will be hopefully in attendance for the vast majority of the hearing. There may be requirements for periodic absences, and simply request that you grant that. Thank you so much.
Anything else? Okay.
Mr. Hearing Examiner, this is Brian Haverly. I just had a quick question for you. With your order yesterday, would it be appropriate in terms of filing non-confidential versions of those exhibits if I just filed a notice by the end of the day with those attached? Would that be sufficient for you?
I'm not sure, you were breaking up a little. You said if you file a notice with those documents attached, is that correct?
Yes, Mr. Hearing Examiner, that was my question. Would
Yes,
that be
of course.
sufficient for your order?
That's sufficient, correct, yes.
Thank you, sir.
With the understanding that if anyone has if any party has any questions about those exhibits today, and I don't know if anyone does, they will be allowed to ask those questions and get those answers without us going into a closed session.
Mr. Hearing Examiner, Rick Alvidrez on behalf of PNM and PNM Resources.
Yes, go ahead.
I do have a preliminary issue, and it cuts across basically all of our witnesses, and it has to do with the exhibits that New Energy Economy submitted. As you are probably aware, they're quite voluminous and cover almost all of the discovery responses that were submitted by the joint applicants to New Energy Economy, and in some cases the exhibits that go along with that, but we have several thousand pages. And those were only uploaded late Monday, and in looking yesterday as best we could, it appears that we don't have the actual discovery responses that were filed by the joint applicants. Instead, what appears to have been uploaded or downloaded on the Dropbox are a bunch of cut and pastes from various of the discovery responses. There are no affirmations that are included with any of the discovery responses. Some of the exhibits that were attached appear to be corrupted. That is, they do not match with what was produced. Some are incomplete, but we have a situation that we've encountered previously, a similar situation where NEE has cut and pasted and tried to create its own exhibits, ostensibly based on discovery responses from PNM in the other case. But these are not the responses as submitted and served by the joint applicants. And so we're raising the issue now because our witnesses are not going to be able to say that, yes, these are their responses. They are something else. Frankly, there's duplication, there are things that are missing, and it would take a great deal of detective work to try and reconcile what NEE is attached or downloaded to what the actual discovery responses have been. We have an objection to the exhibits as have been provided and downloaded by New Energy Economy with respect to the discovery responses. And that would include NE1, NE2, NE4, NEE 6, NEE 7, NEE 9, NEE 10, NEE 12, NEE 14, NEE 16.
I'm sorry, Mr. Alvidrez. NEE
I
6,
apologize.
NEE 7, NEE 9.
If I may start, again, Mr. Lee, I apologize. I do need to slow down. But we see this problem with NEE 1, NEE 2, NEE 4, NEE 5, NEE 6, NEE 7, NEE 9, NEE 10, NEE 12, NEE 14, NEE 16, NEE 17, and NEE 18. We also have some similar issues with exhibits, for example, NEE 23, which is the joint applicant's response to the CCA first set. That's also an issue, and NEE 20, which is the joint applicant's responses to NMAG, New Mexico Attorney General, first set. So those are not complete and do not have affirmations and are not what was served.
Ms. Nanazi, do you have any response?
Yes, there is no question that this was a logistical nightmare. I will just say that to start with. We were trying to download, print, copy, upload all of the exhibits. So I will just first say that. We have the most exhibits of any other party. What I asked before was if we don't want to use some of the answers and we only want to use some of the other answers, do we just include those? And I think that your answer at that time was yes. And so we did not include all the answers because I didn't think that we wanted to introduce all of those answers. So we just introduced the answers that we thought were relevant to our cross-examination. If it's your honor's desire for us to put in, let's say, for instance, in the first set of New Energy Economy Exhibit number 1, there were, I believe, 5 or 6, maybe even 7 supplemental responses. And each one of those has certificate of service, and each one of those has affirmations, and each one of those has, 4 pages of objections. We could redo them and just put it all in there and try to black out, print it all out, black out what we don't want to use. I'm sorry that this was a really difficult, I've never had this experience where we can't just copy and print and give everybody a copy right there. It was extraordinarily time consuming. There definitely are mistakes. There's definitely duplication. There's certain things that were not included, but we were rushing all day. This is all I worked on Monday. So I will tell you that there are some exhibits that certainly have affirmations and some exhibits that don't. But I didn't think that the various witnesses would deny that they affirmed it. So I thought, okay, another affirmation to include, that would be duplicitous. That's where it's at. We could redo them however you say. I understand there's some agreement with, usually New Energy Economy and PNM don't agree, but I agree that there are some mistakes in the exhibits. There's no question about it. Like there's 2 number 1s in there. There's 2 number 4s. There was difficulty turning Excel spreadsheets that PNM provided and then turning it into a PDF. I mean, this was extraordinarily time consuming. And I would have rather just printed out and handed to people, but that wasn't a possibility. So please advise how you would like me or us to handle it.
Well,
If I may respond, Mr. Hearing Examiner, just briefly. The errors go beyond, simply, we have duplicates here and there and that sort of thing. These are changed, and some of the documents that are attached, as I said, are corrupted. I think, meaning that they are not as presented. A spreadsheet is a primary example in response to 6-4. It's both incomplete and corrupt in that it doesn't have the same data as what PNM provided in discovery. But I think Ms. Nanasi has confirmed that what she has uploaded are not the actual discovery responses that Public Service Company and the other joint applicants have provided in this case. And I think it would be error, certainly, to admit them into evidence and to allow the witnesses to be examined on what are admittedly not the discovery response, the actual discovery responses, and exhibits that do have errors in them.
If I could just please, I didn't change any words, anything like that. There's no changes. There are certain interrogatories that were, that we eliminated. So it might say 111216 like that, because I didn't think that you wanted to have things in the record that were not going to be asked about. That is for sure, but it doesn't. There's no energy economy did not change a word or a number in any of all the documents that were produced.
Okay, so you folks are just dropping it all in my lap. It's kind of difficult for me to determine in generalities. I mean, I see all the exhibits. I mean, what am I supposed to do about that? I can't tell you right now which exhibits are going to be admitted and which are not. But I can tell you that I don't expect new energy economy to be able to have the time to actually cross-examine people with all of these exhibits. And so I can't make a ruling in general about any of these exhibits at this point in time. And I guess, Mr. Alvidrez, you're complaining about certain ones of them. I'm not going to take time right now to go through each of those exhibits and make a decision about whether they should be an exhibit that can be, that new energy economy can cross-examine someone about. Can I?
Well, I think the practice has been that these types of exhibits, these exhibits that are created, if you will, cobbled together, that aren't the actual discovery responses, have not been admitted in other cases. And this occurred in I think it was the 2016 rate case, where a similar thing occurred, and we had at the beginning of the San Juan abandonment case, clear instructions from hearing examiner Medeiros about, if you're going to submit an exhibit, a discovery response, it needs to be the discovery response, not something that you have, cut and pasted and put together. And I apologize that, you're finding out about this now, but, these were downloaded late on Monday. We still haven't gotten through all of them in great detail, because there are hundreds of discovery responses and thousands of pages. But we thought we would bring it up as a preliminary matter so that you're aware. So we're sorry about the timing, but we're a victim of the the timing ourselves. So that's, why you're hearing about this now and in the manner in which you're hearing about it.
You've objected to 15 of these. Are you asking that I go through each one of those right now and make a decision on them?
It's up to you, Your Honor. We're happy to handle it any way you'd like it, or, if at the time that NEE proposes to introduce it, to address it at that time.
Mr. Hearing Examiner, first of all, I would object to any characterization that PNM is victimized here. And furthermore, it was over the weekend that Mr. Alvidrez wrote me and said specifically, could you please narrow down the questions that you're going to ask? So I didn't upload the 6 responses to New Energy Economy 1 and all the documents that were attached there. I tried to do exactly what he asked, which is to narrow it down to the questions and answers that I would be asking about, that we would be asking about. So that's what I did to actually respond in part to be as fair to PNM and Avangrid as possible, to show them, yes, these are the questions that I'm going to be asking about. So I didn't include everything. As you know, there are thousands and thousands and thousands of pages in this docket. So that's what we did. In part, in response to PNM's request this weekend.
I notice you have listed almost every one of their sets of responses as.
Sorry, Judge, you broke up. Noticed, listed almost every one of their
Sets of discovery responses as your exhibits. In your first first 18 exhibits are discovery responses from your 18 sets of discovery to the joint applicants. Is that narrowing it down?
Nope, that wasn't narrowing down. That was Friday as a result of your order that said that we had to list everything that we might be questioning about. So over the weekend, all weekend, I did narrow it down. We did narrow it down. And in fact, there are a number of them that we didn't include at all on the actual upload of the Dropbox. And we can go through that if you would like. And I can just tell you that I believe off the top of my head, we didn't include anything from New Energy Economy. Let me just pull it up here. We didn't include anything from the 3rd set. We didn't include anything from the 8th set. We didn't include anything from the 13th set. We didn't include anything from the 15th set. And then over the weekend, I went through every single question, every single document, and tried to narrow only the questions that I was going to ask about on, or we were going to ask about in the first 18 sets. So and I did the same thing with CCA 1. I didn't want to ask about every question that was in CCAE 1. I only asked about the first question. So that's all that's in there. The same thing with the New Mexico Attorney General. So I did exactly what I thought was asked for, which is to narrow, and I spent all weekend doing that. It didn't actually all upload perfectly. There's no question about that. But I did do what I thought was asked, which was to narrow it down so we wouldn't have as voluminous a record unnecessarily. But there are 2 sets that were uploaded twice. And there are, like, I'll just tell you, on New Energy Economy Exhibit 23, there's a Word version and there's a PDF version. And there's the same thing on New Energy Economy Exhibit 20, a Word version and a PDF version, but I didn't want to eliminate anything without asking your permission.
Okay, well, what we're going to need to do I just now saw your revised exhibit list. We're not going to deal with any individual items now. We're going to have to deal with this during the time that's allotted for your cross-examination, Mr. Nazi. That I'm sure is going to eat into some of the time that you'd rather be spending asking questions. But I mean, I don't see any other way to handle it. So I guess I suggest that you make a decision for yourself between now and the time that it comes a time for your cross-examination to decide which ones of these exhibits you really want to use, because we're going to have to go through those and decide whether they should be something that a witness should be questioned about and whether they can be admitted.
Can I ask a clarifying question then? If
Yes.
could we, for instance, then just upload the answer that joint applicants gave, and if there's questions that I don't ask about on those specific ones, then it'll just be part of the Dropbox, and there won't be anything in addition to what we cited, but I'll just put in what the joint applicants originally tendered, and that'll be what we don't ask about in that, we don't ask about in that.
Well, I'd suggest that you do something similar to what the Water Authority did, which is to highlight the question and answer that you intend to ask the witness about in each of these documents that you intend to question the witness about, so that there's some, the Water Authority highlighted in yellow the particular responses that they wanted to deal with. And I think that'll help everybody focus in on what objections there will be, and we can deal with it like that.
And in what way, in what possible way could we do that between now and when we cross-examine? I have no idea. I mean, it's lovely that they thought of that, but that wasn't, I've only been in one hearing where there were documents uploaded to Dropbox and we had one or two exhibits and put them in. This is a much different case, and I don't know how there's not even time in the day, even if I wasn't going to be cross-examining, to do that. Even just in one full day. We have 3 or 4 people here, Mr. Hearing Examiner. We don't have an army of people who can just upload and highlight, and if we would have known that beforehand, we would have done that over the weekend. But instead we did it this other way. I apologize. I don't mean to cause any problems. I thought that we were trying to do exactly what we were told to do. I try to follow all the rules. So.
Well, it's your choice. I mean, if you don't want to do it that way, then we'll just have to spend time during your cross-examination addressing all these issues. I mean, I don't know any other way to do it. I mean, I'm not going to delay the start of the hearing now to go through each one of these objections and each one of these exhibits that you want to use. It's just not possible.
So barring the highlighting version and just producing the new documents, can we upload those and I don't know, call it let's say, New Energy Economy Exhibit 12 star or something like that, like that's the one we're going to use, and or delete the other ones? How would you like it to be done? We'll do that.
I'd suggest that you try to further, excuse me, narrow the list of exhibits that you want to question witnesses about, and in the best way you know how, try to identify which responses you want to question them about, and upload them again to Dropbox with some kind of notation that that this is your revision. If you want to put a star in front of the exhibit that you want to identify in that way, I think that should suffice. It should speed things up.
If I may, Mr. Hearing Examiner, to avoid repeating this, the document that should be uploaded should be the actual discovery response. I mean, I don't care about the certificate of service, but it should be the discovery response with the affirmation, and with if there's exhibits or what have you or supplements, those should be included as well. But that's the the challenge that we've got here.
Okay, well, we'll deal with that when the time comes.
Thank you, Your Honor.
Mm-hmm. Okay, is there anything else we need to deal with? Okay, well, let's go on to witness testimony then. The joint applicants, please call your first witness.
Thank you, Mr. Hearing Examiner. Joint applicants call Pedro Azagra Blasquez.
And Mr. Lee, could you swear him in?
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Go ahead, Mr. Everly.
Thank you, Mr. Hearing Examiner. Mr. Azagra, would you please state your full name for the record?
Yeah, Pedro Azagra Blasquez.
Mr. Azagra, who are you employed by and what is your position?
I'm employed by Iberdrola, Chief Development Officer.
You have in front of you what has been marked as joint applicant exhibit number 1. Do you recognize that, Mr. Azagra?
Yes.
What is it?
That's the joint application that was filed in this case.
And Mr. Azagra, was this application prepared at your direction?
Yes.
Is it the same joint application that was filed in this case?
Yes.
Okay. Mr. Azagra, you have in front of you what has been marked as joint applicant exhibit number 2. Do you recognize this?
Yes.
What is it?
It is the notice of filing the second amendment stipulation with the second amendment stipulation of regulatory commitments.
Mr. Azagra,
I'm sorry, sir. I'm sorry. Notice of filing of the
filing second amended stipulation with the second amended stipulation and regulatory commitments. Sorry about that.
Mr. Azagra, did you participate in settlement discussions in this case?
Yes.
Okay. Were the notice of filing second amended stipulation and the attached second amended stipulation regulatory commitments prepared at your direction?
Yes.
Okay. Are the second amended stipulation regulatory commitments that are attached to the notice, were those the same stipulations and regulatory commitments that the joint applicants and the signatories agreed to?
Yes.
Mr. Azagra, you have in front of you what has been marked as joint applicant exhibit number 3. Do you recognize this?
Yes.
What is it?
That is my direct testimony dated November 23, 2021.
Was this testimony prepared by you or at your direction, Mr. Azagra?
Yes.
Are there any changes or corrections that you would like to make at this time to this testimony?
No.
Are there, if I asked you the same questions today that are contained in your testimony, would you provide the same answers?
Yes.
And these answers will be true and correct. Is that right, Mr. Azagra?
Yes.
Mr. Azagra, you have in front of you what has been marked as joint applicant exhibit number 4. Do you recognize this?
Yes.
What is it?
This is my supplemental testimony and exhibits dated February 26, 2021.
Mr. Azagra, was this supplemental testimony prepared by you or at your direction?
Yes.
Are there any changes or corrections that you wish to make to this?
No.
If I asked you the same questions today, would you provide me with the same answers?
Yes.
Are these answers true and correct?
Yes.
Mr. Azagra, you have in front of you what has been marked as joint applicant exhibit number 5. Do you recognize that?
Yes.
What is it?
This is my rebuttal testimony dated April 21st, 2021.
Was this exhibit prepared by you or at your direction?
Yes.
Are there any changes or corrections that you wish to make?
No.
If I asked you the same questions today, would you provide me with the same answers?
Yes.
Are these answers true and correct?
Yes.
Mr. Azagra, you have what has been marked as joint applicant exhibit number 6 in front of you. Do you recognize this?
Yes.
What is it?
This is my direct testimony in support of Second Amendment stipulation dated June 18th, 2021.
Mr. Azagra, was this testimony prepared by you or at your direction?
Yes.
Are there any changes or corrections that you would like to make at this time?
Yes. In page 26, line 11, the word "to" should be "will." And in page 29, line 22, New York to be deleted.
Are those all the corrections you have?
Yes.
Mr. Azagra, if I asked you these same questions contained in this exhibit today, would you provide me the same answers as you just corrected?
Yes.
Are these answers true and correct as corrected?
Yes.
Mr. Azagra, you have in front of you what has been marked as joint
please.
applicant.
Please, Mr. Haverly, hold on one second. The changes that Mr. Azagra was describing to that testimony, are those marked in the document that was uploaded to Dropbox?
Yes, Mr. Hearing Examiner, let me double check, but they were when I looked at them last, so let me double check. Yes, Mr. Hearing Examiner, if you look at, so there's a little caret on page 26, line 11, for example, and the word "will" is above the word "to."
Just when you're asking a witness about changes that they're making to their testimony, can you indicate for the record that those changes have been made to the document that was uploaded to Dropbox?
Yes, sir, I can do that.
Okay, thank you.
Mr. Azagra, have the changes that you have just gone through on that exhibit been made to the testimony that has been uploaded to the Dropbox?
Yes.
Yes? Is that what you said?
Yes.
Thank you. Thank you, Mr. Hearing Examiner.
Thank you.
And Mr. Azagra, I believe we were on, just to clear this up, if I asked you all the same questions that were included in that exhibit, would you provide the same answers to me as we have just corrected?
Yes.
Okay. And those answers as corrected would be true and correct, is that accurate? Okay. Mr. Azagra, you have in front of you what has been marked as joint applicant exhibit number 7. Do you recognize this?
Yes.
What is it?
This is my July 27th, 2021 supplemental testimony.
Was this testimony prepared by you or at your direction?
Yes.
Are there any changes or corrections that you wish to make to this testimony?
No.
If I asked you these same questions today, would you provide me with the same answers?
Yes.
Are these answers true and correct?
Yes.
Mr. Azagra, you have been handed what has been marked as joint applicant exhibit number 8. Do you recognize this?
Yes.
What is it?
This is my direct testimony in support of the Second Amendment stipulation dated June 18th.
Okay. Mr. Azagra, was this testimony prepared by you or at your direction?
Yes.
And are there any corrections that you have to this testimony, Mr. Azagra?
Yes.
Okay, can you please list those corrections for us orally?
Give me 1 second. I think I answered. Exhibit number 8
Yeah, we're on.
is my July 29th, 2021 rebuttal testimony.
Thank you, sir.
So, sorry about that.
Sorry. So we're all clear that exhibit number 8 is your rebuttal testimony?
Yes.
Okay. And so all those questions, would you like me to go through those questions again, Mr. Azagra, just to make sure that we're all clear? Was that testimony prepared at your direction?
Yes.
Okay. So, Mr. Azagra, do you have any corrections to any of this testimony?
Yes.
Would you please list those?
Yes. Page number 2, line number 9, the word which needs to be added between point and the.
Point and
The, THE. Page number 3, line 33, the word of needs to be of, just one F. Page number 5, lines 20 and 21, insert the provisions relating to the new jobs would also need to be retained. Page number 16, line 7, the word certain should be certainly. Page 17, line 16, the word it should be in. And that's it.
Okay, Mr. Azagra, those changes have been uploaded to the Dropbox copy of the testimony that you have, is that correct?
Yes, they have.
Mr. Azagra, if I asked you the same questions today contained in your testimony, would you provide me the same answers as corrected?
Yes.
Are these answers true and correct?
Yes.
Mr. Hearing Examiner, I move for the introduction of joint applicant exhibits 1, 2, 3, 4, 5, 6, 7, and 8.
Any objection? Okay, joint applicants exhibits 1, 2, 3, 4, 5, 6, 7, 8 are admitted.
Mr. Hearing Examiner, I tender the witness for examination.
Hey, first on the list here is the Water Authority. Ms. Winter?
Thank you, Mr. Examiner. Good morning, Mr. Azagra.
Good morning.
Is it okay if I call you Mr. Azagra? I know that's a bit informal. I just want to make sure you're okay with that.
That's okay.
Thank you so much. My name is.
Miss, before you start, just want to remind you, you have 30 minutes.
Thank you. My name is Nan Winter. Mr. Azagra, I'm with Stelzner Winter Warburton in Albuquerque, New Mexico, and I represent the Water Authority. I believe we have spoken before, is that correct?
That is correct.
But we have never met in person?
No.
Mr. Azagra, would it be fair to say that you have engaged in some dialogue with representatives of the Water Authority over the course of the past few months?
That is correct.
Up to and including yesterday, is that correct?
That is totally correct.
Thank you. Moving to your testimony and generally speaking, among other things, your testimony has focused on the rate benefits, and I use that term rate benefits as a capitalized term, rate benefits and economic development portions of the stipulated regulatory commitments. Would that be fair to say?
That is correct.
Okay, and those regulatory commitments were offered by all the joint applicants, Avangrid, Avangrid Networks, New Mexico Green Holdings, and PNM and PNMR.
Yes.
Okay, thank you. Mr. Azagra, could you confirm for me that joint applicants' November 2020 application contemplated about $24.6 million in rate benefits? Does that sound right?
Yes.
Okay. And it also contemplated about 2.5 million in economic development, correct?
Yes.
And then on April 20th of 2021, the joint applicants, along with the Attorney General and a few other parties, filed an initial stipulation in this matter. Is that correct?
Yes,
And that first stipulation moved the rate benefits to $63 million and the economic development dollars to about $7.5 million, correct?
yes,
Subsequently, on June 4th of 2021, you filed a second amended stipulation. Does that sound right?
yes,
And that added another $10 million of rate benefits to the regulatory commitments of joint applicants, right?
yes,
Okay. And there have been no further formally filed stipulations in this matter. Is that right?
that is correct.
However, as I understand it, Mr. Azagra, your July 29, 2021 rebuttal testimony added another $15 million in rate benefits and an additional $7.5 million in economic development dollars. Does that sound right?
That is correct.
Okay. So as we sit here today, joint applicants have tendered about $88 million of rate benefits, including $6 million dedicated to customers unable to pay their bills. Is that right?
That is correct.
And as we sit here today, joint applicants have offered a total of $103 million in combined rate benefits and economic development dollars. Does that sound right?
That is correct.
Okay. You have read the Water Authority testimony of Mark Garrett filed on July 16th of 2021.
Yes,
Mr. Garrett testified in his opinion that the rate benefits and economic development dollars should be at least $126 million. Do you recall that testimony?
yes,
All right. Would joint applicants be agreeable now to adding additional rate benefit dollars as part of the stipulated regulatory commitments?
Objection, Your Honor.
It's your objection.
That this seems to be exactly what we were talking about in our motion about the constantly changing possible third amended stipulation that is being seen right now for the first time.
Ms. Winter?
There's nothing outside the bounds of this cross-examination that isn't allowable. I'm not sure what the objection is. I'm asking simply whether or not joint applicants would be willing to add additional rate benefit dollars as part of their regulatory commitment.
Okay, I'm overruling the objection.
the answer is yes, if, that would mean, the water utility, to come on board.
I'm
to
sorry,
support-
sir. I'm sorry, sir. Can you start your answer again? You're breaking up.
Sorry. Yes, I think the answer would be yes, if, that would mean that the water utility, will, come on board, with, the stipulation.
All right, thank you. More specifically, Mr. Zagra, would joint applicants be willing to contribute an additional $1 million to create or supplement scholarship programs dedicated to STEM education within the city of Albuquerque and the Bernalillo County metropolitan area?
Yes, with the same condition.
Objection, Your Honor. This is exactly what we were talking about. Specific deals, side deals, that's contrary to your order and the rules, the commission rules, that all parties be part of a settlement conference, number one. And this is going into specific things. Would they agree to $1 million for more scholarship, and maybe there's going to be other specific items that are not written down, so we don't know what they actually really mean. This is a little different even than the testimony that was proffered that said that that certain issues were narrowed, as was discussed before. But now this is going into the specifics of $1 million for scholarship in the Bernalillo County area. What is that? Where is it written? What does that mean? This is not how Mr. Azagra Velasquez says, well, if we can get the water authority, yes, we will agree to certain other Christmas tree bonuses that are not yet known to the parties and the public.
I'm sorry, did you call my name?
No,
Ms. Shanauer?
Yes, I called your name to
Oh, sorry.
hear your response.
I didn't catch it. Same response, Your Honor. This is certainly within the bounds of cross-examination, and we can certainly get into a lot of detail, and I plan to do that.
Okay, well, I'm overruling the objection to the extent that Ms. Nanazi, you believe that the answers don't provide enough detail, and whatever your objection is to the result, I guess, of this question and answer session is you can get at that in your cross, or you can get at that in your brief in this case. But it's not inappropriate for a witness to ask for an attorney to ask a witness whether they're willing to change their position. So the objection's overruled. And Mr. Azagra, you can go ahead and answer that question if you remember it.
Yes, the answer is yes, with the same condition that I mentioned before.
Okay, so I think what you're telling me is that the joint applicants would be willing to contribute $1 million to create a supplemental scholarship program dedicated to science, technology, engineering, and math education within the confines of the Albuquerque-Bernalillo County metropolitan area.
Yep, that is correct. As long as that means that, the water utility then, comes on board with the stipulation.
When you say comes on board, you don't mean support, do you? You're simply indicating that perhaps the Water Authority wouldn't oppose.
Correct. What I mean is that, the water utility will not oppose, the transaction.
With respect to the STEM scholarship program that we just mentioned, would joint applicants be willing to do this over a 2-year period following the closing of this transaction?
Yes.
And would joint applicants be agreeable to a condition that this contribution will be in addition to any existing contributions committed to by the joint applicants?
Yes.
Okay. And would joint applicants be agreeable that this contribution would not be recoverable in rates?
Yes.
All right, thank you. In addition to the STEM scholarships that joint applicants might be willing to offer, would joint applicants be willing to contribute another $1 million to create or enhance apprenticeship programs for technical and professional positions for students in local high schools and colleges?
Objection, Your Honor. Your Honor, I just would like to say that I'd like a continuing objection if this is going to continue like this. So I don't interrupt Ms. Winter's friendly examination as it appears it is beginning. So I just want that to be noted then.
Yes, your continuing objection is noted.
Thank you.
The answer is yes. Again, as long as, the water utility does not oppose.
All right. Would joint applicants be willing to use commercially reasonable efforts to, in the creation or enhancement of these apprenticeship programs to ensure that such programs are made available to high schools in an equitable manner?
Yes.
Would joint applicants be willing to make this contribution in existence in addition to any existing contributions committed to by joint applicants?
Correct.
And would joint applicants be agreeable that this contribution would not be recoverable in rates?
That is correct.
All right. I think, Mr. Azagra, joint applicants, and you agreed with me earlier, that joint applicants have offered about $88 million of rate benefits, including $6 million for customers unable to pay your bills.
Yes.
Okay. Would joint applicants be willing to increase the dollars dedicated to customers who are unable to pay their bills from $6 million to $10 million?
That is correct, as long as the water utility does not oppose.
Thank you. And would joint applicants be willing to round up the $88 million of rate benefits to $90 million by adding $2 more million to the rate credit?
That is also correct. Again, as long as the water utility does not oppose.
Thank you, Mr. Zagra. That's all I have this morning.
Thank you.
Okay. Mr. Albright, are you available?
Yes, Mr. Hearing Examiner, I am.
You reserved 70 minutes. We're going to have to take a break in a little while, about maybe a half an hour. So keep that in mind.
Yes, sir, I will.
Okay, so go ahead.
Mr. Hearing Examiner Peter Gould for just a moment. I'm whenever Mr. Azagra is answering, his connection seems to be a little bit unsteady. I'm hearing a lot of interruptions between his words, so I'm wondering if he could please check his connection for the audio and make sure that it is strong. Thank you.
Can you hear me now better?
Yeah, I think I can hear you a little bit better when you are closer to the microphone.
Okay, sorry about that.
Okay, okay, Mr. Albright, go ahead.
Yes, good morning, Mr. Blasquez.
Good morning.
My name's Jeff Albright. I represent J. Albright. I'm from J. Albright Law LLC, and I represent Bernalillo County in this proceeding. Have a number of questions and areas that I do want to go through. I would like to begin by referring to your July 29 rebuttal testimony. I believe that's exhibit KA Exhibit 8, I believe.
Yes, Mr. Albright.
And in looking at, if you would take a look at page 4, some of my questions are somewhat similar in nature, where to what the Water Authority asked with respect to the testimony of Maureen Reno. And I would also like you to have available Bernalillo County Exhibit 3, which is Ms. Reno's July 16th, 2021 testimony. Do you have that available?
Yes.
It has not yet been admitted into evidence, obviously, until Ms. Reno takes the stand, but we'll make reference to it for purposes of this discussion. So beginning at page 4, essentially, you make a reference to increasing the rate credits provided in regulatory commitments, number 1, from 50 million to 65 million. Do you see that?
Yes.
And would you have, and obviously based upon the testimony you just gave with respect to the Water Authority, you would not have any problem if either other parties wanted to increase that amount, or if the commission at the end of the day found that the overall rate credits should be more than 65 million, correct?
Well, we believe, that is what we have agreed. And I think, I've made it very clear to the water utility also, the condition to allow. So we feel this is, what is acceptable for us, to be approved.
And there was a broad range of what that rate credit should be from various witnesses. Isn't that correct?
Yes.
And with regard to the 15 million at shareholder expense on page 5, lines 5 to 7. You would also agree that besides, and at lines 13 and 14, besides the 12.5 million in shareholder expense for indigenous community groups in the Four Corner regions, you would make some similar contribution to the economic development in areas in which PNM serves, correct?
Correct.
And you mentioned that what I don't see in there at page 5, lines 16 through 20, you say overall the applicants do not have any significant issues or concerns with these recommendations. And I assume you're referring to these recommendations being those of Ms. Reno, correct? At line 16.
Yes, to the ones above.
I'm
Okay.
sorry, sir.
Yeah, to the ones mentioned above.
Of the ones mentioned above. What are the issues you do have remaining with Bernalillo County from your perspective?
I think, you were requesting the chairman of the board, to be one of the independent directors. And I think, we believe, the chairman of the board should be, someone that, is, on the day-to-day related to the company, because set up the agenda, establishes a lot of procedural things. And I think in exchange for that, we are happy, that, one of the independents to become, the lead director of the board of the utility. So that will be, one of the items I think is pending. I don't know if there are other items pending. You probably may remind them to me.
All right, let's go through some of the issues that we believe the county still has with regard to this. Would you turn to your direct testimony in support of the second stipulation filed on June 18, 2021? That should be JA Exhibit 6.
What page, Jeff?
I'm sorry?
What page?
Well, we'll start, yeah, I just want to make sure he had that. We'll start at page 1. There's a table of contents, but past that, I want to go to table 1. Or page 1, not table 1, page 1.
Okay.
All right, and I'd like to refer to footnote number 1 to begin with. You identify at lines 13 through 15, you state that there are 13 other parties to this proceeding filed on June 4, 2021, is attached as JA Exhibit PAB-1 stipulation, and then the footnote 1. Do you see that in lines 13 through 15?
Yes.
How many of those 13 other parties are not within PNM's service territory?
I think I will refer, to the PNM team, to explain that.
Well, it's in your testimony. That's why I was just asking you. You have 13 parties there listed, and you have a footnote listing the parties.
Sure, but I don't know how many of them they have or they don't have, service territory under PNM.
Okay, fair enough. And which PNM witness would best be suited to answer that question?
Probably Don Terry.
I'm sorry, Mr. Terry?
Mr. Terry, yes.
All right, would you also turn to page 4, please? Same document.
So Jeff, we're looking at what we have as joint applicants Exhibit 6, and there's pages at the top. Can you use those page numbers in directing us?
Oh, I'm sorry. I don't think I can. What I have in front of me is the printed copy with the page numbers at the bottom. I'm sorry.
You said page 4?
Page 4.
Yep, okay.
And let me interrupt for a moment. When someone other than the examining attorney and the witness starts speaking, that new person needs to identify themselves for the court reporter. So please, Mr. Haverly, I mean, that was you just speaking there in case Mr. Lee did not get it.
This is Brian Haverly. My apologies, Mr. Hearing Examiner. You're right. I apologize for forgetting that. Mr. Lee, I apologize as well.
Thank you.
Do you see on that page at lines 18 where you refer to long-term transmission planning?
Yes.
You make reference to long-term transmission planning. Is this related to your goal to have an RTO or to have Avangrid PNM serve as an RTO?
I think again, Mr. Terry will be the right person, to give detail on that. But among other things, yes, I think it's both, what are the long-term planning that the utility has, for the state in relation, to transmission and other potential things related to that. But I think Mr. Terry will be the right one, to address that.
To address the RTO issue in general?
Yes.
Do you have any idea who would pay for the infrastructure with regard to PNM or Avangrid operating as an RTO? Or again, is that a better question to ask Mr. Terry?
He's the one who knows that.
Would you turn to page 6 of the same exhibit, please? On lines 9 through 15, those figures of 73 million represent before the adjustments for either Ms. Reno's suggestion or for ABCWA, correct?
That is correct.
Do you know how much per customer per month the increases would be on a person's bill with those additions?
With what additions?
With the additional additions that either Ms. Reno recommended or with ABCWA.
I don't have that information with me.
Do you know who might have that information?
I think Mr. Camp or Mr. Terry can come back to you with that.
Okay. In footnote 2 on that page, on page 6, I notice you list there's a list of proposed rate credits from various people. Do you see that?
Yes.
Why was Mr. Kempling's figures not included in that list?
I don't know.
You know who Mr. Kempling is?
Yes, he's a witness.
Okay, he provided testimony for the Attorney General, correct?
Correct, yes. I know that, he has now some roles, in FERC, and I don't know if there was some ruling, if I remember well, basically taking out some of his information or, I think I rely on the legal expert to explain that.
Okay, turning to page 7, you talk about $10 million increase in low-income energy efficient benefits as compared to the commitments made in the initial STIP filed with the Commission on April 21, 2021. Do you see that testimony at lines 4 through 8?
Page 7, what line?
On page 7, lines 4 through 8.
Yes, sorry, yes.
Okay, how is that commitment going to be determined as to who benefits on the energy efficiency benefits?
I think that's one of those examples where, the local management has to work with the parties, to agree, on that. So I think, that's the local management to decide that.
When you say local entities, are you talking about just those within PNM service territory?
I think I will leave to, to Mr. Terry to answer that question, because he knows, how he has to deal with this.
Okay, and turning to page 8, a similar question, and let me know if this is more appropriate for Mr. Terry as well. At lines 2 and 3, you have joint applicants are providing $2 million to help these people obtain reliable electric service. It says still people in New Mexico who cannot afford the cost of running electricity to their homes. $2 million. Who is going to determine that, and how is it going to be determined?
I think same thing. My responsibility is to sign off on the amount and the implication that it has for us from an economic value point of view. I think, this is something Mr. Terry, will be able to answer to you how he's dealing with this to be implemented. Of course, in accordance with whatever, may have been agreed in the stipulation that deals with how to implement these matters.
Turning to page 9 at lines 4 through 8. There's a commitment to bring an additional 150 full-time jobs over a 3-year period. Do you see that?
Yes.
And of that 150, up to 20 of those are going to be at PNM, correct?
That is correct.
Are those 150 jobs going to be, where are those 150 jobs going to be located?
I think, we have agreed, to create 150 jobs. At least 100, and 30 of those will not be related to PNM, so will be outside of the utility. I think, just to confirm, I think 100, of those new jobs, will be within the Albuquerque, Bernalillo County metropolitan area.
You say 100 of those?
Yes, 100 of those new full-time jobs within the Albuquerque, Bernalillo County metropolitan area.
Okay,
and those 20 that have been within PNM, they will be full-time jobs for electric service craftsmen.
Would you turn to page 12, please? Same document. And they are making reference to the text under commitment number 8.
Yes.
At lines 9 through 11, you state joint applicants will work with the New Mexico Attorney General and other stakeholders that are stipulation signatories to propose improvements to the program that satisfy the utility cost test. Did I read that correctly?
That is correct.
Why is it limited only to the signatories? Are you not going to work with staff? Are you not going to work with Bernalillo County? Are you not going to work with other entities?
That is what we agreed. I'm sure, the local team, will also agree. Probably that is, he's more than happy to work, with the county, since we have been, we have, accepted, most of your proposals. And I'm sure they will be more than happy to work with the staff. That is for them to decide.
Okay, thank you for that. And the same question somewhat applies on page 13, where you speak at the beginning, lines 1 through 5, where you talk about commitments. Commitment number 1 provides joint applicants will work with staff and the New Mexico Attorney General to propose a low-income electrification for all program to improve access to electricity for low-income New Mexicans. You see that language?
Yes.
Did I quote that correctly?
Yes, that is correct.
Okay. Would you include the county in that conversation as well?
I think for me, staff and New Mexico Attorney General is probably, the right parties to work on this. And I think I will let, Mr. Terry to decide if there are specific reasons why it's only, these two parties.
generally on pages 14 to 15, we talk about the commitment of the discussion of the board of directors.
Actually,
You have those
if I can-
pages in front of you.
No, one second, I think in commitment 11.
Pages
you know,
14
which
and
is the-
15.
But let me go back before. You were commenting on commitment number 11.
I've moved past
the-
commitment number 11.
Yeah, but let me go back to commitment number 11. I think we are happy that, the program. So we are happy to report on the results, to the commission and all the parties in this case. That's, what we have, amended in our, in our review till later. Sorry about that. Let's continue.
All right, page 14 and 15, with regard to the board of directors. Ms. Reno had proposed having a majority, of having 3 of 7 as independent directors. Do you see that where you make reference to that at 11 to 14?
Yes.
Lines 11 to 14 on page 14.
Yes.
All right, let's take a look at that. You have there that PNM Board of Directors will be comprised entirely of New Mexico residents, at least 40% of whom, and I believe we've agreed on either 2 of 5 or 3 of 7, shall qualify as independents defined in the rules of the New York Stock Exchange and disinterested. And then you footnote that and you cite to 303A of the New York Stock Exchange listed company manual. You see that?
Yes.
Okay, so with respect to New Mexico residents, I know this is a sensitive subject, but a New Mexico resident could be anyone who moves into New Mexico, correct?
Yes, as long as you're a resident there, that could be an option.
So it could be anyone from Texas, Colorado, even California, correct?
I think the important thing will be to be a resident in New Mexico. It's not just, somebody based somewhere else and come back and forth. So I think the people that we expect here is the people that have the track record and the expertise, to be, residents. And most of the times for us, that would be people that they have been here for a long time and they know the local dynamics.
And it could be somebody from Syria or from Russia or from some other country, correct? As long as they reside in New Mexico, correct?
I think those 2 specific examples, I don't think it will be that case.
So who makes the decision as to who the independent directors are?
Well, it will be a proposal, and then you will have to comply with the wording of the final of the stipulation. And I think we will have to prove that those board members are residents in New Mexico. And I think for us to be resident doesn't mean you've been resident now for a month, and it will be people that they've been resident for a long time.
But who makes that decision? Is that an Avangrid decision? Is that an Iberdrola decision? Who makes the decision of who sits on the board?
The board proposes, the board members.
Which board members?
The independent board members. They're referring to those independent board members or all the board members, because all of them will be, New Mexico residents. So the board has to propose those, and they will be approved in an AGM. That's how it works.
Okay, I'm not quite sure I fully understand just yet, so I'm going to ask it another way. So from what I last saw, one of the directors who was just appointed to the board is Patricia Vincent-Calanche. She has a term through May of 2022, correct?
I don't know that information by heart.
Okay. Who decides who's going to be on the board of directors of PNM?
The board of directors, the directors to be proposed are to be proposed by the board of the utility. Okay, and they have to be approved.
Approved by whom?
Usually it's an AGM, in an annual shareholders meeting. You propose that. The board approves that, and then there is an annual shareholders meeting that approves that. That's how it usually works. Okay.
So it's done by a majority of the shareholder votes, correct?
Yeah, that's how usually it works.
And that's how it would work in this case?
As long as I know, yes, unless there is a specific, regulation that I'm not aware of.
You oppose the county's recommendation with regard to having the chair of the board as one of the independent directors. Why?
I think as I explained before, Mr. Albright, the chairman, is someone that we expect in a controlled subsidiary, as this one will be, to be, on the day-to-day, to have a lot of time to know what's going on in the company, to prepare very well the agenda of those meetings. And therefore, an independent, we don't expect to be the right profile. But in exchange for that, upon the request of the county, I think there is the figure of the leading, lead director in many boards. So we are more than happy to propose that one of the independents will be the lead director, at the board level. And as you know, the lead director can propose items in the agenda and has many, many actions, empowered. So that is why we would prefer, to go that direction.
Well, I won't provide testimony with regard to why I think that's a lame excuse not to have the chair as an independent director. But are there?
Brian Haverly, objection.
I'm sorry, Mr. Haverly, I couldn't hear you.
Sorry, Mr. Lee. This is Brian Haverly. I object to that. That statement is argumentative.
I'll restate the question. Are there other places in the United States that you're aware of where the chair of the board is an independent director?
I think in the case of controlled subsidiaries, it's very hard for me to think about in how many cases you have an independent, board, chairing a controlled subsidiary. Holding company, publicly traded holding companies, that's a different thing. But controlled subsidiaries, I cannot think of that many. I cannot think of anyone right now, but I'm sure they may be, but I cannot think about those. Publicly traded holding companies, yes, but this is a controlled subsidiary.
And both Avangrid and Iberdrola are holding companies, correct?
Avangrid is a controlled subsidiary under the New York State, stock exchange, rules. Iberdrola, yes, is a holding publicly traded parent company.
And here in New Mexico, Avangrid, it will be the first, what we call vertically integrated company that Avangrid will be in charge of, correct? Where they will be both by vertically integrated, I'm speaking of both responsible for generation and for distribution, correct?
No, because they are totally separate subsidiaries.
I'm sorry?
They are separate subsidiaries. You do not have, under the utility also the generation business unless it's regulated. All the Avangrid, renewable business is separated in a different, a subsidiary. So by becoming another, subsidiary of Avangrid in the regulated business, it will not change anything that you have right now under the utility of PNM. There is no change there at all.
Excuse me, I'm sorry. Mr. Hearing Examiner, I'm having a real hard time. Is it possible that you could ask the witness to slow down so I could hear him better?
Yeah. Mr. Albright, is this a good time to take a break?
We can take a break now, Mr. Hearing Examiner. This will work fine.
Yeah, I guess what I'd ask is that someone check Mr. Azagra's connection. Are you in a PNM office building? I don't know where you are, but if you have some support, some technical support, I'd ask that we take a 15-minute break now and someone from PNM help improve this audio connection that we're working with right now, because it's not very good. So let's take a 15-minute break. Let's come back at 11 o'clock, and hopefully the audio will be improved.
Okay, thank you very much.
Thank you.
11 o'clock.
Mr. Haverly? This is the reporter.
Yes, Mr. Lee.
There's just a lack of crispness in his words. So perhaps if he slows down, if you can't change that bandwidth, that may be helpful.
That's very helpful to know. Thank you, Mr. Lee. I appreciate that.
Thank you.
We'll work on it on our end right now.
Thank you.
Mr. Hearing Examiner, before we go back on the record, we've been doing a few things here. Is this better?
Are you speaking from Mr. Azagra's computer?
I can speak myself, just to check
okay.
if you can hear us better now.
I think you're better. Yeah.
Yes, Judge.
So Mr. Hearing Examiner, we went to a single source of audio. So it may pick up my voice, but show Mr. Azagra's face, because we had to go to one source of audio to try to improve it.
Say that again.
I'm not sure how the Zoom's looking, if there's an active speaker role, because we had to go to one source of audio. So I don't know if I appear to you or not when I'm talking.
Well, you appear on Zoom, but from what I understand, there's the speaker appears on YouTube. So David and I can see everyone, but I think that the people on YouTube may only be seeing whoever YouTube thinks is the speaker.
I think just to check, Mr. Lee, can you hear me better now?
Yes, sir. Thank you very much.
And I will try to speak as slowly as possible.
Thank you, sir.
Okay, Mr. Albright, are you ready to go again?
Yes, Mr. Hearing Examiner, I am.
You have 40 minutes left.
I was just going to ask. Thank you, sir. Mr. Velasquez, I want to have a couple of questions to ask in response to your answers here. Back to the members of the board. Who proposes members of the board? You said that they were voted on by shareholders, but who proposes members of the board?
In our board subsidiaries, you have, committees of the board itself that, proposes, to the annual shareholders meeting, the candidates, to be approved, for becoming board members. So it will be those committees or those boards, of the subsidiary that has, to approve, a new board member, the ones to take care of that. So just to be very specific, so PNM Utility Board, they will be proposing those board members. For approval.
And those committees are formed internally by PNM?
Yep. Usually, in our case, usually the nomination, the compensation, committee and nominations committee, as you know, we have proposed in this transaction to be composed of the three independents of the board. So, it may very well be that will be the committee that we will have to propose those board members.
And another question related, you mentioned that one reason not to have either a majority member or to have the chair of the board as an independent director was because of accounting issues. Which witness is in the best position to answer questions concerning what accounting protocols, rules, regulations preclude having the chair as an independent member?
I think it's two different items. One is questions about, the accounting implications. I think Mr. Camp and we are both happy, to answer those questions. And I think, that's different, from the chairman, matter that you raised.
Did you say Mr. Camp?
Yes, Mr. Camp and I think we're both comfortable to answer that.
So to ask you at this point, what are the accounting limitations that preclude that or argue against having the chair as an independent member?
Yeah, I think that the accounting issue and the chairman are not related, unless the chairman was to have, specific functions, that then, may be an issue. I think, the chairman is more, what you have in a control subsidiary. You want to make sure that the agenda, the day-to-day, it's someone that is, knowledgeable everything going on in that company, and therefore, can, address the things appropriately. That's why I think, we are proposing the chairman not to be one of the independent directors, and one of the independents to become a lead independent director. That I think is a compromise that we are proposing to the county proposal.
So is it your opinion that an independent director cannot have a good grasp of the day-to-day functions of the company?
I think that's not that's a comment, an opinion by you. I think, what I can say is that, most of the control subsidiaries that I know, there are no independents at all. Not even, one or chairman or anything. But I think in this case, as you know, we are proposing, not only to be 3 independents, but also, according to the NICEC regulation, but also disinterested. And I think in your case as a county, you were proposing the chairman. I think we're, counter proposing to you to be the lead independent director. That's, well beyond what, most of the control subsidiaries that I know have.
Would you turn to page 24 again of the second amendment stipulation, testimony in support of the second stipulation, same document we were on before.
Yep.
Okay, and with regard to the carbon reduction task force, was this provision part of an agreement reached with one of the other interveners in the case?
I don't remember by heart, how this clause, came here in those settlement negotiations, but it was part of that. And I think, on this specific matter, again, Mr. Terry will be the right person, to address, how to implement and, and how this will be laid out. Has been the responsible, for the local management.
Okay, and on page 24 at lines, beginning at line 19 through 22, you state PNM will also report to stakeholders the emissions reduction resulting from the seasonal operation agreement for the Four Corners.
I'm sorry, Mr. Albright.
I'm sorry, let me slow down. Yeah, let me slow down on that. So at lines 19 through 22, you state PNM will also report to stakeholders the emissions reductions resulting from the seasonal operations agreement for Four Corners Power Plant for so long as PNM remains a joint owner of the plant. Have I stated that correctly?
Yes.
Right, and what do you mean for as long as PNM remains a joint owner of the plant?
I think since this is related, to Four Corners and the different agreements that are, happening there, I think, the PNM executives, Mr. Terry, or any other of his colleagues, should be the right people to ask them about this.
As part of the task force as well, you're recommending that there be a separate person hired to serve as an environmental officer, correct?
Yes.
And that job is not counted amongst the other jobs that you've separately referenced, the 150 jobs, is that correct?
I think as I mentioned before, 20 of those jobs will be, craftsmen, so therefore I think this doesn't seem to be that position.
And the salary of that person, the salary of that person who fills that spot would be paid for by the ratepayers, correct?
I think you need to ask Mr. Terry. He's running the utility. He will run the utility, and he's the one to answer those questions.
On page 25 of your the same document there, at line beginning at line 10. You talk about incentive compensation for all relevant PNM executives will include goals related to achievement of PNM's 2040 carbon reduction targets. Do you see that language?
Yes.
Why would you have incentive compensation for something that's required under the ETA anyway?
I think again, Mr. Terry is the one, but I think, sometimes in these settlement discussions, we agree on things that sometimes, they are, sorry, I'm going to slow down. I think sometimes in these settlement discussions, you agree on things that are already part of the regulation. They are part of, the legislation, happening right now. I think in the case of, the compensation to the management, it's not strange now, to be requested, by proxy agencies, by investors and by other people that they want also, these commitments to be part of the goals that the executive management are. So when we were requested this proposal, we fully understand this.
So again, a better question to ask of Mr. Terry?
Yes, if it's just to know if that's part of the existing regulation, I think you should ask him. But this is a dynamic that I see globally going on right now.
Would you turn to page 29, please? On lines 7 through 13, you make reference to Ethosphere Institute. Do you see that reference at line 9?
Yes.
Does Avangrid or Iberdrola pay membership to Ethosphere to be in order to get those results? Do you have a membership fee that's required?
I don't have that information with me. I'll be
Who
more
would?
than happy to. I'm more than happy to get that information and provide it to you.
Okay, that would be helpful. Could you turn to page 30, please? Beginning at the bottom of page 30 and continuing to page 31, we talk about, with respect to Iberdrola, and certainly Iberdrola is now part of the proceeding. Just to be clear, does Iberdrola agree to subject itself to the jurisdiction of the Public Regulation Commission after this proceeding is concluded and in subsequent proceedings before the PRC?
Yes, it does.
And you'd be willing to make sure that's a condition that you would agree to, not just with the commitments that are here in the stipulation, but for purposes of regulation by the PRC.
Absolutely.
Okay. Thank you. Would you turn to page 33, please? There are several references throughout that page, and I'll just ask questions in general related to the debt. So isn't it true that that this merger or acquisition, whatever we want to call it, that the PNMR debt is being retired or being assumed by Avangrid Iberdrola, correct?
Yes, the PNMR debt, the 1 billion approximately debt, will be assumed by Avangrid.
Okay, and PNMR will be, or PNM, as it is listed on New York Stock Exchange, will be removed from the New York Stock Exchange after some period of time after the closure, correct?
It will stop being listed, the holding company that's traded right now.
Okay, so that will remove one competitor with regard to access to capital, correct?
I don't know. Brian Haverly, sorry, I object to the vagueness of that question.
I don't understand the question.
Mr. Albright, rephrase it.
I'll rephrase it. Does the removal of PNMR from the New York Stock Exchange eliminate one potential recipient of investor funds?
I think, you will get two alternatives now versus only one. You will have, a company right now, which is PNMR, with 1 billion of debt at the holding company level, having access to equity, but, with that huge penalization that you have with that debt. And now you will have, two alternatives. One will be Avangrid, which is publicly traded in the US as a pure US player. And then you will have the parent company, one of the second or three largest companies in the world. So you will have two access to equity instead of just one. I think in addition to that, you know that we have already financed the acquisition, through an equity issuance at Avangrid. And Iberdrola, days, after, the announcement of the transaction, already, financed, the proceeds that they needed to put into Avangrid. I think in addition to that, that this will give you access now to the Iberdrola Group. And as you know, the Iberdrola Group has more than $15 billion of cash and equivalents, available credit lines, facilities right now. So I think in terms of, the access to equity, there is no doubt that this transaction enhances, and the debt position of PNMR enhances its current situation.
What happens to the PNM debt?
Nothing. The utility
So the PNM debt remains, correct?
It has to remain.
And that has to be assumed by Avangrid or Iberdrola, or who assumes that debt?
Well, it's consolidated, from an accounting point of view, but the utility debt stays at the utility. The one that is moved to Avangrid is the holding company debt from PNMR. There is a benefit to the utility because its parent company doesn't have $1 billion of debt any longer. And that's a huge issue, should there were issues in the parent company. If there was to be an issue with holding company debt that PNMR has right now, you may believe the utility is isolated. It's not isolated. You may have, a parent company bankrupt. That's a huge issue. So that's why, I think for, the utility, the owner of the utility becomes a much healthier, owner as opposed to today.
Is there risk that is run by Avangrid with regard to its bond rating by assuming the additional roughly $4.3 billion of debt that PNM has?
The rating agencies have already addressed the implications, and they don't see any issue, from a rating point of view because of this transaction.
I'm sorry, who doesn't?
The rating agencies have already analyzed the implications of this merger, this acquisition from a rating analysis point of view, and they have addressed both for Avangrid and for Iberdrola. And in both cases, because of the financing approach that has been done both at the Avangrid level and the Iberdrola level, the transaction itself has not triggered, any issue for both companies.
And Avangrid has agreed, isn't it true that Avangrid has agreed that in the event of a BBB rating with a negative watch, that dividends would be suspended, correct?
I'd like to go exactly to that, to the wording, because I think it's, when you go below, but I'd like to, to know exactly, if you can point me to exactly, that commitment, I'm happy to read that again.
I think I can find it, but I may just have to run across it. I will, as we proceed here, I think I'll run into it.
Okay. I think it's when the rating arrives at BBB minus.
BBB minus or triple B?
BBB minus. No need to mention the credit watch negative one.
Don't you think that's too late when you have a BBB minus with a negative watch?
No, it's not negative watch, BBB minus, without negative watch. You don't need to have the negative watch, only when it gets to BBB minus.
Mr. Hearing Examiner, could I just check on how much time I have left?
You have 20 minutes.
Okay, thank you. Would you turn to Exhibit A of your same document? Exhibit A was the stipulated regulatory commitments. And would you look at, are you there? Are you at your stipulation there?
Yes.
Okay, would you take a look at on page 4, commitment 3 and commitment 4, and we'll address them sequentially.
Yes.
Commitment 3 is Albuquerque street lighting. Do you see that?
Yes.
And it says that the city of Albuquerque can contract to fix the street lighting and submit an invoice to PNM for the repairs. Have I read that correctly at the end of that paragraph?
Yes.
Is that an expense that would be passed on to consumers, or would that be borne? And when I say consumers, or is that an expense that would be?
Mr. Albright, Judge, can anybody hear me?
Yes.
Yes.
Mr. Albright dropped off on his last question completely, and I couldn't get a hold of anybody. His question was, and it says the city of Albuquerque can contract to fix the street lighting and submit an invoice
to PNM for the repairs. Have I read that correctly?
Yes.
Mr. Vasquez, have I read that correctly?
Yes.
Okay,
Yes.
So who pays for that expense? Does the city pay for that? Is that an expense borne by PNM? Or does it go to general consumers in some kind of recovery in a rate case?
I think, those details, Mr. Terry will be able to explain that to you.
Okay. And on the next one, Albuquerque Airport Substation. I won't read all of that into the record, but isn't that something that PNM should be doing anyway?
I think, besides Mr. Terry answering, again, many times, when you are in settlement discussion with parties, you are requested, to put into the stipulation some clauses that maybe, as you correctly say, it's something that anyhow it should be done. But, I think by putting that there, I think it's some comfort that because there may be a change of control in that utility, the new controller entity becomes aware of this and, make sure that this is done, appropriately. But I'm sure Mr. Terry, will be able to say that to you.
And would you turn to page 12? It would be commitment number 20 with regard to the extinguishment of debt.
Page 12, okay.
Page 12 of the stipulation, commitment number
Yes.
20, extinguishment of debt.
Yes.
You there? Okay. It talks about Avangrid will extinguish all debt at PNMR, reducing it to zero within 90 days following the closing of the proposed transaction and maintaining it at zero going forward, as long as Avangrid has an indirect ownership interest in PNMR, unless authorized in advance by the commission. Have I read that correctly?
Yes.
Okay, what do you mean by indirect ownership interest?
You know that right now, there is a holding company and you have, Avangrid Networks, and then you have Avangrid. So as long as it's not a direct ownership, that's the reason why you say indirect, just to be, more specific.
Okay.
If you were to say direct, it will not be the case right now. So we will be, not having an obligation to comply with this.
Would you turn to page 14, please, and commitment number 28?
Yep.
And this commitment talks about the BB minus or its equivalent with any of their credit rating agencies with a negative watch. So I just want to be clear that per your testimony, that has now been changed to BB minus, but without a negative watch, correct?
That is correct. I think as you mentioned, because of, the testimony that you, another party, provided, I think, we came back, and in my rebuttal testimony, to those testimonies, I confirm I deleted with a negative watch. And also, I'm including, and I'm going to read, how it will read, so there is no misunderstanding, that, PNM, shall promptly notify the commission within 5 days if PNM's credit rating falls to an investment grade credit rating below BBB minus or its equivalent. PNM's total balance sheet debt, including, short-term debt, measured using a trailing 13-month average, will be included in this action plan for informational purposes. For purposes of this paragraph, references to credit rate agencies will include Moody's, Standard & Poor's, Fitch, of any of their successor firms. Just to be very precise, I'm repeating again what I put in my testimony, so it's clear what we delete and what we keep for you.
Okay, and I don't see anything in here throughout your testimony with regard to a rate freeze. So my question is, why, given the circumstances that we've been in, is a rate freeze not contemplated as part of the merger agreement, particularly with the COVID and particularly with all of the things that are being proposed here?
I think Mr. Terry knows the day-to-day of, the new rate cases to come, not to come. and the different circumstances. It was clearly debated, in the settlement negotiations, and as you can see, all these parties agreed that this was the right approach, and I'm sure Mr. Terry will come back to you with, a very specific answer of why that, that is not something that, could be acceptable for us.
Would you agree that even with the rate credits and the other economic development that's being proffered, that if there is the potential that consumers could be impacted by a $300 million rate increase as a result of the Four Corners, depending upon the decision by the commission?
I think, as you know, Mr. Albright, there is a separate case, with that matter, and I'm sure Mr. Terry will be able to answer that question for you.
Do you think the consumers would strike that? I'd like you to turn to page 20 and commitment number 42, please.
Commitment number? Commitment number, sorry?
I'm sorry, yeah, 42 with regard to the Regional Transmission Organization.
Yes.
How would the RTO benefit PNM customers?
I think Mr. Terry is the one that, as we mentioned before, can explain to you about how the RTO will be dealt with. And it seems to us that becoming part of, a regional transmission operator clearly, opens, a lot of opportunities and different, best practices and dynamics between, states, etc. That I think our experience is that benefits, all the utilities involved. But I'm sure, he will be able to explain that to you in detail in this specific case because he knows the local dynamics.
On page 21, but under the same commitment, number 42, state that participation in the Western EIM, EDAM, or other similar market would not constitute participation in an RTO. Do you see that statement?
Yes.
Are you aware that roughly, well, tens of millions of dollars have been spent by ratepayers for joining the Western EIM with regard to system upgrades, computer software, technical expertise?
I'm not aware.
Are you aware of that?
I know. I'm not aware.
How would the RTO interface with something like the Western EIM?
Again, that's, Mr. Terry to explain to you because he's the one who knows those local dynamics.
And one question, I think I know the answer already, but with regard to the capital investments that would have to be made in order to create an RTO, would that be, who bears the cost of that? Do consumers bear the cost of the capital expenditures and infrastructure needed for that?
I think you know the answer, Mr. Terry.
Mr. Terry,
answer that.
I thought that might be the case.
That's what you have local management for, so he will be able to answer that question. He knows the local regulation that I don't know.
On page 21, under the Carbon Reduction Task Force, item 43, commitment 43. At line, the lines aren't numbered obviously on this, but in the middle of that, on page 21, you state, or it's stated, PNM shall have a dedicated full-time employee who will identify and with the assistance and support of PNM, apply for third-party funding opportunities. Do you see that?
Yes.
Is that anticipated to be a new employee, or come from existing people?
Can be both. Important thing is, Mr. Terry to explain to you, which one.
But that is separate from the environmental expert that's going to be hired by PNM, correct?
That's a separate thing.
Separate person, okay.
Mr. Albright, you have 5 minutes.
Thank you. On page 22, same item, 43, you indicate that the reduction in emissions resulting from the seasonal operations agreement by the joint owners of the Four Corners Power Plant for so long as PNM remains a joint owner. With the agreement that's been reached with the Navajo, is PNM expected to remain a joint owner of the Four Corners?
I think again, Mr. Terry, will explain to you the agreements he has for Four Corners, and I'm sure he'll be able to go into that detail.
I'd like you to turn to your July 29, 2021 rebuttal testimony. JA Exhibit 8.
Only one thing that I think I did wrongly, Mr. Albright, is I just saw the page again. When I say triple B minus, it's triple B, not triple B minus, okay?
Triple B, not triple B minus. All right, thank you for that clarification. So that is a change to the testimony then, correct?
Yeah, that is correct. It's just because I had it, written down, what you put and what I put, and I missed the hyphen or whatever.
All right, at page 7, lines 1 to 2, you answer a question and you state, Iberdrola hereby commits that it will be subject to the commission's jurisdiction for as long as it owns PNM. You see that statement?
Yes.
Are there any plans by Iberdrola or by Avangrid to sell PNM to another potential buyer after a certain period of time?
No, I think, we have committed not to sell anything at least for, the next 10 years. And if you see the history of Iberdrola and Avangrid, I think, we are here to grow. So, we're not here to buy and sell. There are always specific reasons why things can happen, but in this case, I think we're very comfortable to commit for at least 10 years.
Okay, Mr. Hearing Examiner, that's all the questions I have for this witness. So, Mr. Blasquez, I want to thank you very much for your candor and responsiveness to the discussions and pointing us in the right direction for those to whom we should address some other questions. So thank you very much. Appreciate it.
Thank you, Mr. Albright.
Okay, thank you. Mr. Gould, you're next. You have 30 minutes.
Yes, Mr. Hearing Examiner, before I start, a couple of process questions. Number one, I need some guidance on whether I would be able to do redirect if there is some confusion that about the witness's testimony during later cross. As an example, Mr. Azagra Velasquez just corrected himself on the on the triple B minus issue, which I'm going to go into. But if that comes up in later, if those kind of issues come up later in cross-examination, will I be able to do short recross to clarify what I think the record should reflect?
Well, Mr. Haverly has to do redirect.
Okay.
I'm not inclined to.
Okay.
Find anymore.
And number two, my second question is, during the cross-examination by Mr. Albright, Mr. Zagra Velasquez referred a lot of the questions to Don Terry, which were, he qualified them as operational questions. I'm wondering if you would allow me to cut short my cross-examination of Mr. Zagra Velasquez and move some of that time to Mr. Terry, because I had some of the same operational questions about items he mentions in his testimony, but clearly feels that Mr. Terry is better answering. So I would agree to cut my cross of Mr. Zagra Velasquez to no more than 15 minutes, but then we would have 30 minutes for Mr. Terry tomorrow. Would that be acceptable?
Yes.
Okay. And with that, I'm ready to start my cross-examination.
Okay. So you have 15 minutes.
Okay. Good morning, Mr. Zagra Velasquez. How are you doing today?
Good morning, Mr. Gold.
Would you, I want to clarify this issue about the limitations on dividends issuance that the joint applicants could have agreed to. So I want you to get a couple of pieces of, actually 3 pieces of testimony in front of you that you can look at in referring to this cross-examination. If you would first look at or have in front of you the testimony of Michael P. Gorman in opposition to the stipulation, which is NM Area 4. And specifically, I'm looking at pages 26 and 27. So if you could get that in front of you.
Okay.
And the second piece of testimony I would like you to have in front of you is the July 9th, 2021 rebuttal testimony of Robert D. Kump of the joint applicants. I believe it's joint applicant exhibit 13, which listed on your list. And the final piece of testimony I would like you to have in front of you is the July 29th rebuttal testimony of Joseph D. Terry. I don't have in front of me the joint applicant number for that one, but I'd like you to look at pages 16 and 17 of that when I ask you the questions. Okay. Do you have all 3 of those pieces of testimony?
Just 1 second, I'm missing one.
Okay.
Yes. What pages did you say?
For Mr. Terry, the pages are 16 and 17. For Mr. Kump in his July 29th rebuttal, it would be pages 3 through 4. Okay, and I want to start with Mike Gorman's testimony in opposition.
Okay.
You recall that there was some confusion about the dividend limitations that the joint applicants had agreed to when you were being cross-examined by Mr. Albright, and you made a correction from triple B minus to triple B. Do you recall that testimony?
Yes.
Okay, would you go to page 26 of Mr. Gorman's testimony? There's a question that starts at line 15.
Yes.
Would you read the answer to that? Would you read the question and the answer to that into the record?
Yes.
Thank
Joint
you.
applicants commit that PNM will not pay dividends or distributions except for contractual tax payments at any time that PNM's debt rating is below BBB or its equivalent with any of the credit rating agencies, unless approved by the Commission in a proceeding opened for that purpose. PNM shall notify the Commission within 5 days if PNM's credit rating falls to an investment grade credit rating below BBB or its equivalent with any of the credit rating agencies. PNM's notice shall include an action plan to improve an investment grade credit rating below BBB or its equivalent. PNM's total balance sheet debt, including short-term debt, measured using a trailing 13-month average, will be included in this action plan for informational purposes. For purposes of this paragraph, references to credit rate agencies include Moody's, Standard & Poor's, and Fitch or successor firms.
Okay, thank you for that. And now, Mr. Zagra Velasquez, could you turn to Joint Applicants Exhibit 13, which is the July 29th, 2021 rebuttal testimony of Robert D. Kump, at page 3 of that testimony.
Yes.
Would you just look at that very quickly, starting at line 17 and going to page 4, line 14? You don't need to read that. I just want you to review that so I can ask you a question.
Yes.
So indicate to me when you've read it and you're ready for a question, please.
Just to make it clear, you're referring to the affiliate transaction, no public data exchanges.
No, I'm referring to, you might be in the wrong exhibit. I'm referring to the July 29th rebuttal testimony of Robert Kump. This is the Joint Applicants Exhibit excuse me, I misspoke. It is Joint Applicants Exhibit 16, 1-6. That my bad.
Okay.
I apologize.
Exhibit 16, page 3.
And if you just look at the testimony of Mr. Kump on line 17 on page 3 up through line 14 on page 4, and indicate to me when you're ready for a question.
Yes.
Okay. In that testimony, that rebuttal testimony, Mr. Kump is agreeing to the amendment of this distribution of dividends as proposed by Mr. Gorman in his testimony in opposition. Isn't that a fair statement?
I think there is just, one difference.
Okay,
I think one line. I think all the rest is the same.
point out to me the line that you're thinking is the difference.
I think in the first one that I read, it says PNM's notice shall include an action plan to improve an investment grade rating below BBB. And I cannot see that in Mr. Kamp's testimony. That's line 27 and 28.
Yeah, if you look at Mr. Kump's testimony on page 4,
Oh, sorry,
line
yes, sorry.
8,
You're right.
it says,
9, 8 and 9.
yeah,
Yes, that's okay, yes, you're right.
PNM's notice shall include an action plan. So
Yes, sorry. You're
so
correct.
in that
Yes,
testimony, okay, I'm sorry, I keep interrupting you. So why don't you finish your answer?
Yeah, let me just read because I was mixing the lines. Give me 1 second. Yes, I think it's the same.
Okay, so could you read those 2 lines into the record that you were confused about on page 4, lines 8 through 10?
Yes, PNM's notice shall include an action plan to improve an investment grade credit rating below BBB or its equivalent.
Okay, and with that, would you agree with me that Mr. Kump, on behalf of the joint applicants, is agreeing to the language that was proposed by Mr. Gorman in his testimony of July 18th, his testimony in opposition?
Yes.
Okay, and then finally, just to complete this little line of cross-examination, if you could look at joint applicants exhibit 24, which is the July 29th, 2021 rebuttal testimony of Joseph D. Terry.
Yes.
Mr. Gold, you have 5 minutes.
Thank you.
Yes, I don't have it numbered. You need to tell me.
Okay, it is at the top of the page, it said July 29th, 2021 rebuttal testimony of Joseph D. Terry, page 16, 16, and 17. Do you have that testimony?
Yes.
And would you just quickly review that and let me know when you're done reviewing?
Just to make sure I'm in the right, in that phrase, says, a staff witness Reynolds states in his testimony in his opposition to the second amendment stipulation. That's the one you're referring to?
No, I'm looking, if you look at line 6 on page 16, it says, can you summarize proposed modification to ring fencing provisions? Do you see that question?
Sorry, proposed modification to?
Proposed modification to ring fencing provisions. That's how the question starts.
Yeah, sorry, because I don't have the document number. So I need to look for page 16. Give me a second.
Yeah, this is the July 29th rebuttal of Mr. Kump. I mean, Mr. Terry.
July 29th?
Yes.
Yeah, page 16. Just give me a second.
Page 16, starting at line 6 and going into the line 12 on page 17.
Okay. Yep. What line, sorry?
Starting on line 6 with a question.
Yes.
Just look at that and then going down to page 17, line 12.
Yes.
And is it a fair summary of Mr. Terry's rebuttal testimony to state that he also indicates on behalf of the joint applicants that they are agreeing to Mr. Gorman's changes to regulatory commitment number 28 as they refer to the dividend restrictions?
Yes.
Okay. With that, Mr. Shanauer, I'm done with my cross and I'll pass the witness.
Okay, thank you,
Thank you,
Mr.
Mr. Hall.
Okay, Mr. Marks, you're next. You've reserved 25 minutes.
Okay, thank you. Good morning. Can you, Mr. Azagra, could you please refer to Sierra Club's Exhibit 3?
Yes.
Okay. And that's a document titled Avangrid Climate Policies.
Correct.
Are you familiar at all with that document?
I am, but I think, Mr. Camp is, I think, the right person to speak more about the Avangrid, specific, topics. But I'm happy to listen to your question, and if I can answer, I will.
Okay. Does that document accurately state, to your knowledge, the company's policies?
I will have to read the document, but I think yes.
Mr. Shanauer, I move to admit the Sierra Club Exhibit 3.
Any objection? Sierra Club Exhibit 3 is admitted.
And Mr. Azagra, do you see under point 2A?
Sorry, I cannot hear you very well.
I'm sorry. Do you see under point 2A that the company seeks to eliminate its scope 1 greenhouse gas emissions by 2035, which are its own direct emissions?
Yes, I can read that.
Would you agree?
Was that scope 1?
Yes.
Thank you.
Would you agree that goal can be met by the company retiring its own emitting generating plants, or by transferring those plants to other entities who would keep those in operation?
I think Mr. Trump is the right person to answer that because he knows those details.
Mr. Shanauer, we didn't reserve time for Mr. Kump. We were expecting that Mr. Zagra Blasquez could answer questions about matters related to carbon emissions, given that he filed rebuttal testimony to Sierra Club's case. Could we possibly get 5 minutes with Mr. Kump?
And reduce your time with Mr. Zagra Blasquez by 5?
Mr. Shanauer, can I actually see how much he defers to Mr. Kump before we make a specific request, thinking about it?
Okay.
Thank you. Can you turn to the merger agreement, which is Exhibit 3 to your original direct testimony? And can you look at page 73 with clause 6.19?
Page 73.
Yes.
Yes.
6.19. This clause obligates PNM to divest its ownership interest in Four Corners with a closing date for the exit as promptly as practicable, but no later than December 31, 2024, correct?
I'm sorry, but I cannot find the.
We're looking at 6.19.
This is not the one. You said page 73?
Yeah.
It's page 73 of 97. The actual page number in the document on the bottom of the page is 68.
Yeah. Yeah. Okay, I think that's correct. Sorry, but I'm looking at the bottom of the page. Sorry about that.
Oh,
So
thank you, Mr. Shanauer, for helping.
6.19.
Okay. Do you agree this section obligates PNM to file to divest its ownership interest in Four Corners with the closing date to be as early as possible, but no later than December 31, 2024?
Yes.
Okay. And that it obligated PNM to enter into agreements for the exit of Four Corners substantially in the same form of that made available to parent prior to the date of the merger agreement?
No, we did not obligate to them, to PNM, to anything. I think PNM was already, put in front of us a plan and a negotiation they were holding, because they were already working on that and, negotiating. I think, we felt very comfortable, with what they were doing, and we thought it was the right thing to put that into the merger agreement. So we did not obligate to them to anything. They were already doing that, and in the absence of the merger, they would have done that anyhow. And that's why, we felt, it was the right thing to put that also into the merger agreement.
That's similar to some responses you gave earlier. You're saying they are something that might happen otherwise, but you did in fact add it to the merger agreement. Was it? Yes?
Yeah, correct, because they were already doing that.
And was it Avangrid's request that 6.19 be added to the merger agreement?
I don't remember, who, proposed to put it there, but I think, once they were having that matched with our, a strategy of not, interested in owning, stakes, in operating coal assets that we have, in the company. And therefore, I'm very comfortable also to say that, that was also something I felt very comfortable to put into the merger agreement.
Okay, and you and Avangrid had gotten a copy of the sale agreement with the NTEC prior to executing the merger agreement?
I don't know the answer to that.
Okay. Well, you said you knew that they were already had something in progress.
Yes.
And it says that, in the specific language says that it is substantially the same form made available to parent, which is Avangrid. So the agreement requires that they execute a certain agreement, not a general agreement to exit Four Corners, correct?
No, I'm sure, we were provided, those agreements, for us, to become aware. And okay. I'm sure, we were comfortable with, what they were, doing, and okay. We found that acceptable.
Okay.
But I don't remember by heart, what we were provided.
Okay. When the merger agreement was signed, were you and Avangrid aware that the sale agreement with NTEC requires PNM to vote against closing Four Corners during its remaining ownership unless NTEC agrees to the early closure?
I think those specific questions about those agreements, I'm sure Mr. Terry will be the right person to answer that.
So you personally can't recall if you knew that?
I cannot recall right now.
Okay.
But I'm sure he will have the answer for you.
Mr. Terry,
Yes,
but Mr. Terry's with PNM.
correct. They were the one negotiating, so that's why I'm sure they know all the details and they can explain that to you.
I'm sorry, Mr. Zagra. I don't mean to be argumentative, but we need to know what Avangrid knew at the time for the purpose of this proceeding. We need to know what Avangrid knew about this agreement.
We knew they were negotiating. We knew that they were negotiating an agreement that basically will conclude in the exit and the sale of the stake in that power plant and the request, for securitization. So we knew that was what they explained to us, that was what they were negotiating, and we supported that. And that's why not only we supported and we were comfortable with that, and that we also put it in the merger agreement.
Okay, so you were comfortable that PNM agreed not to vote to close Four Corners between now and December 31, 2024?
I think you need to ask Mr. Terry, that specific question, because I think, sorry, go ahead.
Okay. I can't ask Mr. Terry if Avangrid was comfortable with that. Yes. Is there someone who in Avangrid was paying closest attention to what happened to the Four Corners plant?
Oh, we had, we had our lawyers reviewing, what we were, updated with by PNM. And I think, in the end, the important thing is, that they had a negotiation going on that ended up in a sale of a stake. I don't, think that, because of the agreement, as you say, it will cause a delay in the shutdown of the power plant. I think it's the other way around. But I'm sure, Mr. Terry will be able to explain that in detail to you. Well, our main focus was the exit of the power plant, that, we wanted, to confirm that what they were telling us is exactly that, and we confirmed that. The details of what they were negotiating, I think they know that better than we do.
Okay, so the main focus was to make sure that, consistent with your climate policies, that you didn't have a coal plant on PNM's books after 2025.
I think it was consistent with what they told us they were doing, and that matches our policy that you just mentioned.
Okay, great. Now, Sierra Club has criticized the merger and criticized the NTEC agreement because of that prohibition on PNM voting to close the plant in the next 4 years. Does the stipulation contain any provision that alters paragraph 6.19 of the merger agreement?
Can you ask the question again?
Okay. Does the stipulation have any provision that changes clause 6.19 of the merger agreement?
I cannot answer that question.
Okay. Does the stipulation contain any provision that changes the requirement in the NTEC sale agreement that PNM vote against closing Four Corners for the next 4 years?
I don't think so.
Okay.
I think, what we have made public, we have made it clear that as Iberdrola Avangrid, I think we are more than happy, to help and accelerate shutdown of any coal facility as we have done in the past in our own, our other owned coal facilities that we used to have in the UK and in Spain. And I think, we are more than happy to help there as much as we can. But I don't think, we can, get into what PNM has agreed, which I think, again, is an acceleration of the shutdown already. And I think probably, Mr. Terry is the right person to explain that to you.
Since the case was filed, has Avangrid suggested any amendments to the merger agreement or to the purchase and sale agreement that would change the requirement that PNM not vote for closure in the next 4 years?
I don't recall, us requesting anything like that.
Okay. Do you know, has PNM suggested any changes or amendments to the merger agreement or to the purchase and sale agreement that would change the requirement that it not vote for closure in the next 4 years?
I think PNM tried probably their best, to achieve, sorry, because I need to be next to the speaker, otherwise I don't know if you see me or you hear me. I think PNM, I know that they tried their best to accommodate, to what you are, suggesting right now. I think, in the end, they got the best contract they could, which I think is a very good contract with an acceleration of the shutdown of the facility anyhow. And I think there is a moment that's the best they could get. And their interest was to exit, that power plant. And there is a dynamic right now with many companies trying to exit those facilities. They did not have a controlling stake in that company. They were not running the power plant. So they had a limited, approach, what they can do themselves in that power plant. So it seems, at least to me that, that agreement that they've been negotiating for a long time, it was, very appropriate. And, I think, I'm sure they tried their best to see their angles, to accommodate to what you were proposing. And if they have not been able to do so, is the reason why I'm probably, we have not been able to insert other things in the stipulation that I guarantee to you, Iberdrola Avangrid will be more than happy to. But there is a moment they have, they arrived where they could arrive.
Okay. So, Mr. Azagra,
Mr. Marks, you have 10 minutes.
Okay, Mr. Azagra, you said earlier that Avangrid and Iberdrola support closing Four Corners. And you also said that in your rebuttal testimony, support an early closure to Four Corners. In light of that support, does Avangrid support revising the stipulation so that PNM can vote against Four Corners closing early?
I think, probably very well that topic, I'm sure it has been part of the conversations we have had in the past with one or several parties. And I think, we have tried our best, to see that was, achievable. And that in the end, the contracts, are what they are, and probably, better than, were expected to be achieved. And that specific item, we will be more than happy, to not only for this asset in general, we have been for more than 25 years, doing, exactly what you said, which is to try to move in the right direction. It seems to me that, probably, there is a moment that, this is the best, they could get. And, I think, I cannot, to commit, to changing a stipulation or to propose something in the stipulation, or even to support that you do not oppose, such proposal that I cannot deliver. I think, you should probably, ask Mr. Terry if he feels comfortable that's something, he could do.
What will Avangrid and Iberdrola do to support early closure of Four Corners now that you've given up your future subsidiaries vote? What can you do besides say the words "we support it"? Are you willing to put in to make a financial commitment to the early closing fees beyond what you're legally required to do?
I think we'll be more than happy to work with the parties to say there are angles that have not been identified before that help to get an earlier closure. But again, the details of everything related to that case, because there is a different case, but also those agreements, I think PNM executives are the right ones to discuss it.
Yet Avangrid agreed to this merger, and with a particular clause that has this particular NTEC sale contract part of it, correct?
Oh, yes, we had a merger agreement that it has a clause that basically relates, to this matter, as you have, read, in 6.19.
Okay.
And it has been already delivered because they reached an agreement and they have filed, into the commission, for, securitization, etc. So I think, PNM has delivered in this clause. So this is not an item any longer pending for us, to close the merger.
Okay. Do you have any personal concern that the merger and the agreement that PNM joined with NTEC will prevent a vote to close the plant in the next 4 years?
I think you should ask, Mr. Terry for that.
I can't ask Mr. Terry about your personal opinion. Mr. Zagra, I
don't
understand
have
you're part of a company that prides itself on being environmentally progressive, correct?
Oh, yes. I think I'm very comfortable to say yes to that.
Okay, certainly. And you don't have any personal concern that if there was a vote in the next 4 years where the other parties were ready to close four corners because of this deal that you're part of, that vote will fail?
Again, that's an example of a question that for me goes into the details of the different agreements that are related to that. For us, the important thing was just, that they deliver on what they had told us they were doing, which is to reach an agreement to exit their ownership. And we were more than happy. Now you're asking me, well, will Iberdrola and Avangrid try their best, to help? I don't know how, because I don't know how, we can help right now. But if there is any angle we could help, okay? And then you say, well, then financially, well, sorry, then I need to analyze that. But if there is any angle that, allows, this plant to be shut down earlier, I think we'll be working to try to get it done. But I think, right now we are subject to contracts that have to be delivered.
Okay. Thank you. Mr. Schanauer, I am done. I probably used all my time, but if I had 2 minutes left, I would use them for Mr. Kump.
You actually have 5 minutes.
Okay. Can I have that for Mr. Kump then?
Yes.
Thank you. And Mr. Zagra, thank you. I think this is something
Thank you very
we both
much.
care about. So.
Okay. Thank you very much, Mr. Marks.
Thank you.
Okay, we're going to take a lunch break now. It's going to be an hour. So let's come back at 1:15.
Mr. Schanauer?
We're in recess. Well, okay, before we go off the record, Mr. Gould.
Yes, I think I made a mistake that is reflected in the record. I printed all my copies of PNM's testimonies from the filed copies. When they uploaded them to Dropbox, they, I think they have a practice of counting the first page and whatever table of contents as pages 1 and 2. So when I was referring to the pages in the testimonies of Mr. Kump and Mr. Terry, when I was cross-examining this witness, the page numbers that I was referring to were the ones on the filed copy. So, for instance, page 17 would be page 19, page 16 would be page 18. And I didn't realize that when I was cross-examining. So the record may be a little bit unclear. And I think that was part of the confusion of the witness in trying to find exactly what I was talking about. So in the future, we will make sure my paper copies have reflect those changes in numbering so that there's no unclarity in the record. But I just wanted to note that at this point before we went too much further.
Well, thank you.
Mr. Schanauer?
Mr. Albright.
Yes, Mr. Hearing Examiner. Given the number of questions that were deferred to Mr. Terry, with your permission, I'd like to split the time a little differently between Mr. Kump and Mr. Terry. I had 60 minutes for Mr. Kump and 30 for Mr. Terry, and I'd like to split those equally, 45 and 45. It's the same 90-minute total.
Okay. All right.
Thank you, sir.
Mr. Hearing Examiner, I think that you might have seen that in our exhibits that we filed on Friday, we said that we would like to give up our cross of Mr. Fridley and Mr. Small, which is 40 minutes total, and add certain times. If I could tell you those now.
Actually, I read your filing. You want 100 minutes for Mr. Zagra Blázquez, you want 100 for Mr. Kump, and you want 60 for Mr. Darnell, right?
Yes. Thank you so much, sir.
Yes, that'll be okay. Okay, we're in recess till 1:15. Thank you.
1:15.
close the transfer agreement in place.
Are you up next, Ms. Nancy?
I am.
All right, be gentle.
Okay, and I'll try to speak slowly, but let me know.
I will.
I get excited, so then.
I know, but you're allowed to. Hey, Jason, how you been?
Oh, my back's acting up on me again, David.
I'm sorry to hear that.
Yeah, but I took a little walk over the lunch break and it's feeling a little better.
Well, that's good.
Yeah. So I'm trying to remember, do you drink Dr. Pepper?
I do not.
What was that drink you were, when you're in person with us, what are you drinking? Just water?
It was water.
Oh, okay.
I've got 2.
Oh.
I drink water by the gallon.
Oh, okay. That's probably healthy.
It's very good for me, but occasionally I'll drink some water with some hops and barley in it.
Okay, well, funny you should say that. So if you're ever in Albuquerque, I own a bar.
Oh, what's it called?
It's called Juno. It's a brewery and cafe, and actually that's where I walk for lunch. But
well, I'll tell you what, I'll be there. I promise you. I'm going to be in Albuquerque quite a bit. As luck would have it, I have a top secret clearance now.
Oh.
So I wind up going to the Air Force Base and doing some work.
Okay, well, we're right. We've not been to my office, but my office and my bar are both just north of downtown, near the courthouses, but you probably won't be at the courthouse.
No, but it's JUNO.
JUNO, yeah.
All right, I'll be there.
Yeah.
When are you there?
Pretty much as much as I can.
I'm ready when you
folks.
are.
Yeah, you're ready, David?
Yes, sir.
Okay. Well, let's go back on the record. We're now on cross-examination with Ms. Nanazi of Mr. Zagreb-Blasquez, and you've reserved 100 minutes. So go ahead.
Thank you. I just want to say we did upload our documents and to the site, and they have an R before them for revised. And we also have a revised new energy economy exhibit list. So not all, but many of them. I'll be referring to those, Mr. Zagreb-Blasquez. Good afternoon. I am Mariel Manassi.
Excuse me. I'm sorry, I missed that whole thing. Mariel, did you say that this is Brian Haverly. I apologize, Mr. Lee. Are you saying that you have new documents up on the website that you want us to refer to when you're asking them questions?
Yes. They have an R before them for revised.
Okay, I've not seen these yet.
Can I start now, Mr. Hearing Examiner Schanauer?
Yes.
Thank you. Good morning, good afternoon. My name is Mariel Nanasi, and I am the Executive Director and Counsel for New Energy Economy. Welcome to New Mexico, Mr. Zagreb-Blasquez. First, I'd like to go over some rules. The making of sounds are difficult for the reporter to accurately capture, like So if you can answer with words, that will make for a better record. Further, I'd like you to give as short of an answer as possible, because I have a very short period of time with you. And if there are questions that your counsel needs to follow up with, he will have that ability. If you don't understand a question that I ask, please say that you don't understand it, and I will do my best to rephrase that. Is that fair?
Yes, thank you very much, Mr. Nanasi. I just wanted to confirm you can hear me well now, Mr. Lee.
Yes, sir.
Perfect.
Sir, you are here as the Chief Development Officer and a member of the Executive Committee of Iberdrola, and also a member of the Board of Directors for Avangrid, correct?
Yes, that is correct.
Today, the hearing examiner has already granted WRA motion, has admitted the WRA1 about taking administrative notice of climate change. its causes, and its likely consequences. You heard that, correct?
Yes, I did.
Included in that administrative notice is the fact that a predominant source for greenhouse gas emissions is the combustion of fossil fuels by power plants. Correct?
If you can point to that document so I can read it.
Sure, you could go to the Dropbox and you could look under WRA. And you can see under Exhibit 1,
Yes.
and it's on the second page here, and it's the very first line, and it says, a predominant source for greenhouse gas emissions is the combustion of fossil fuels by power plants, by vehicles, in buildings, and by industry.
Yes, I can read that.
And do you agree with that?
Yes.
As part of Avangrid's environmental, social, and governance, also known as ESG goal, Avangrid not only acknowledges that climate change is real, but acknowledges the need for decarbonization because of the more frequent and impactful weather events. Is that true?
If you can also tell me where that is, so I can.
No, I'm just asking you.
Yeah, but you're referring to a document by a statement by Avangrid.
Well, I'm asking you about Avangrid's environmental and social governance, also known as ESG goals. Avangrid not only acknowledges that climate change is real, but acknowledges the need for decarbonization because of the more frequent and impactful weather events.
But are you reading that from a specific document, or you are saying?
I'm asking you if that's what you understand Avangrid's ESG goals are and why.
Yeah, but are you pointing to a specific document from Avangrid or not?
Not right this minute.
So you are creating that sentence for Avangrid, just for me to understand. I just need to understand.
I'm just asking you a pretty simple question about the Avangrid goals of the Avangrid's ESG goals. Decarbonization, is that an Avangrid goal?
Yes, it's an Iberdrola and Avangrid goals, decarbonization.
And the reason is because there are more frequent and impactful weather events. Is that also true?
I think it's clear on a worldwide basis that the climate change is happening, and there is a lot of things influencing that. But again, I'm not here to have a direct relationship proven between one specific item and another one. But it's clear that there is a climate change going on right now.
How come Avangrid and Iberdrola did not join in support of the motion to take administrative notice of climate change, its causes, and its likely consequences?
Can I see that motion?
Sir, can you please answer the question?
I'm looking for the document. Where do we have our rejection?
Sorry, but you're not allowed to be asking council or anybody else questions when there's a question pending.
I'm asking you, where do we have our rejection? Because I'm looking for it and I cannot find it.
I didn't ask you about a rejection. I asked you, how come Avangrid and Iberdrola did not join in the motion to take administrative notice of climate change, its causes, and its likely consequences?
I think one thing is to fight as we do for many years in order to get the right environment, and I think we are very proud of what we have done
when nobody was, defending the things that we have defended, for more than 20, 25 years. Another one is, to get into filing documents, with, statements.
I'm sorry, sir. Number one is,
Sorry, let me just look at here, because otherwise, okay, so start again. I think, one thing is what we are very proud of doing, which is to help the world, from a green environmental approach for the last 20, 25 years. Another one is, to file documents in the middle of a merger that we don't have, the time, and the effort, to confirm that it's 100% accurate. Okay, there are many statements there. I think we will have to go through the document, review that, and make sure, we are 100% comfortable, signing that. I think we have signed many, many things, but it takes, a lot of time. So that's why, that's probably the reason why, we were not comfortable addressing that.
Excuse me, Mariel. I just got a text from Joseph Yar for the hearing officer. If I could just interrupt you for a second. Mr. Yar, Mr. Shanauer said he's in the queue to be let back into the hearing. Here we go. Okay, thank you. Appreciate it. Sorry about that, Mariel. And I apologize to the witness too.
Thank you. Is it your testimony that the reason the joint applicants did not sign on to the motion to take administrative notice was that you were overwhelmed with work on the merger and couldn't look at a 3 or 4 page document?
No, I did not say that. I think I said that, there are, I'm sure, statements, in this motion that we were not comfortable, to agree with 100%.
Okay. Could you please look at NEE revised 14? NEE exhibit 14 revised. Are you there, sir?
Yes, 1 second, because we're trying to. Yes, I have the document. What page do you want me to go to?
I want you to go to interrogatory NEE 14-1.
14-1.
First of all, you answered this
Yes.
question, correct?
Just to confirm, is the how many gas plants, that one?
Correct.
Yes, please go ahead.
And you answered that question, right?
Yes.
And so the total megawatts of gas Iberdrola owns in the US and worldwide is 16,965 megawatts of gas. Is that correct?
Yes. The answer, I don't have it added, but, is United States 636, indirectly, 400, in Spain, 5,695 and 353, Mexico 9,146 and 202, and Brazil 533, and none in the UK. Those are the right numbers.
And so if you could look at interrogatory number 14-3, you answered that, right?
Just 1 second. Yes.
And there it says that Iberdrola is invested in 6 nuclear plants in Spain, totaling 3,177 megawatts. Is that correct?
That is correct. That is what it says in the response.
Can you please go, sir, to interrogatory NEE 14-6? It's on the next page, 5 of 9. And in the first paragraph, second to last sentence, it says solar accounts for under 2% of the owned / co-owned operating portfolio. Is that also correct?
Yeah, just give me 1 second, because I'm getting there. Yes, solar accounts for under 2% of the owned co-owned operating portfolio. Yes. I have it in front of me.
Can you go to 14-10, please, sir?
And Mr. Zagreb-Blasquez, when you read, could you slow down for the court reporter?
Yes, sorry about that, Mr. Hearing Examiner. 14.10.
14-10, it's the top, your answer is the top of page 7 of 9.
Yes.
And on April 23, 2007, Iberdrola acquired 100% of the stock of Scottish Power for 11.6 billion pound sterling. Is that your answer to our question 14-10?
Yes, that is correct.
I'm going to read the question of 14-11, and could you please read the answer that you gave when you answered New Energy Economy 1411 on June 3rd, 2021. The question is as follows. Did Britain's Energy Regulation Authority, OFGEM, investigate Scottish Power for false advertising? If yes, what was the result of the investigation? Can you please answer what you responded to?
This is Brian Haverly. I object. I don't understand the relevance of these questions.
Mr. Nazi?
I believe that this has already been determined that the behavior, especially the misconduct of Iberdrola and Avangrid in the United States and worldwide is, I believe your words were material and relevant in the last order. And so the best indicator of future action is past behavior. And I believe that this will be discussed further in this hearing.
Objections overruled.
Should I read the answer?
Yes, please.
Okay. There was an investigation that began in 2010 into the Scottish Power retail business failure to ensure that information provided to customers.
Sorry, sir. Into the Scottish Power retail business?
Yes, let me say it again. There was an investigation that began in 2010 into the Scottish Power retail business failure to ensure that information provided to customers in respect of marketing was complete, accurate, and not misleading. Scottish Power ultimately agreed to a settlement package with Ofgem in October 2013 of £8.5 million in respect of this matter.
Thank you, sir. And could you go down to what's page right after the end of the questions, and there's a self-affirmation. And you signed the self-affirmation regarding NEE interrogatories 14.1 through 14.5, NEE interrogatory 14.7, NEE interrogatory 14.9 through 14.12. Is that correct? And
yes.
And now could you please go to New Energy Economy Revised 1D. So it's our NEE Exhibit 1D. Let me ask you something. isn't it true that if the merger is approved and the Four Corners abandonment and sale to NTEC is approved, the Four Corners power plant will no longer be included as a PNM Avangrid Iberdrola asset, but the coal will still burn?
Sorry, but I'm in a different document. So
I'm not asking about a document yet, sir. I'm just asking the question.
Sorry, can you ask again?
Isn't it true if the merger is approved and the Four Corners power plant abandonment and sale to NTEC is approved, the Four Corners power plant will no longer be included as a PNM Avangrid Iberdrola asset, but the coal will still burn?
I think if they complete the sale of, the stake in the power plant, it will be accounted. I think in terms, when, the facility will continue running, I think I refer, to Mr. Terry's, answer, because he knows those details much better than I do.
So it won't be accounted for Iberdrola, PNM, or Avangrid, but it may still run. Is that your testimony?
No, I said, I don't know the details of, how much longer the power plant is going to be running or not. I'm saying that once the exit is, completed and, executed, then you will not be accounting because you have sold the stake. So you don't have a stake any longer in a coal facility.
So it won't be accounted against you, is that right?
It's not a question against. You will not be the owner of that stake any longer. So you will not own a stake in a power plant. It's not against anybody. You just don't own a stake in a power plant.
During the courtship between Avangrid Iberdrola and PNM PNMR during the year 2020, there were many emails exchanged between you and Charles Eldred, Executive Vice President of Corporate Development and Finance, on the Four Corners exit deal, correct?
Objection, Brian Haverly, vague. I don't know what courtship means. I don't know what many means.
What was the second thing you didn't know?
Many.
Oh, many. Overruled.
Sir, can you please answer? Were there many email exchanges between you and Charles Eldred about the Four Corners exit deal?
There were different emails, for many topics, because, he was one of the persons I was negotiating with.
Okay, and if you could look at the documents, those are the answers that were provided by the joint applicants to NEE 157. If you just scroll down, these are emails between you and Mr. Charles Eldred, who's also known as Chuck, correct?
Yes, these are emails between Mr. Eldred and myself.
And so could you look at what has been labeled in the right-hand corner as page 14 of 139? And it's, are you there?
Is that an email from February 7th, 2020?
Correct. And it says, Pedro, just wrapped up discussion with Thomas on Four Corners. We addressed in more detail our plans with the Navajo deal. I'm bringing Patrick Apodaca, our general counsel, with me, so was hoping Schwartz can be at the meeting. It's important that David understands how the ETA will apply to Four Corners abandonment, which Patrick can talk lawyer about it. Thanks, Chuck. Is that what the email says?
Mr. Hearing Examiner, Brian Haverly, objection, hearsay.
Overruled.
Is that what the email says?
That's the email. What you read is what I have in front of me.
Okay, so let me ask you something. You ultimately went to a meeting with David Schwartz, your lawyer, Avangrid Iberdrola's DC lawyer, your financial person, Thomas Rosen from BNP Paribas, Paribas, and Mr. Apodaca in New York on February 12th, 2020. Is that true?
I know we had meetings in New York. Where that date is here, because I don't see that.
Okay, if you don't know the date, but if you were at a meeting subsequent to this email, is that correct?
I don't remember the meeting in New York is subsequent to this email or before. I know we had at least, I think I had a meeting with Patrick, with the General Counsel of PNM. I think I had one meeting, maybe two, but no more. Maybe
Was
one.
that it?
I don't remember if it's before or after this email.
Was it in New York?
When I met with Patrick, yes, I met in New York.
Okay, and was Mr. David Schwartz there as well?
Yes, I think Mr. Dave Schwartz, and I think also Mr. David Gertzweil, and probably speaking by heart, Thomas Rosen were there.
What did Mr. Apodaca tell Mr. Schwartz about the ETA's application to Four Corners Power Plant?
Objection, Mr. Hearing Examiner, hearsay.
Overruled.
I don't know because I was not in that conversation.
What is your understanding about what this email meant?
I think this email is PNM explaining to us and my advisors taking care of that, not myself directly, the advisors. That's why I was not in that conversation, meeting, conference call, video, or whatever they had. I think what this means is PNM, in the case of Jack, has been updating what PNM was doing in relation with Four Corners. I think they have updated our financial advisor, who is Thomas Rosen, and also they were going to update my legal advisor, Mr. Dave Schwartz, and potentially David Kurzweil, on both the Four Corners matter, but also on the ETA, matter. So that's what it means. They were updating us on what they were doing or what was going on that matter.
Thank you. Did Mr. Apodaca tell you then, or have you come to learn that PNM was found to have imprudently invested in Four Corners Power Plant?
I never discussed with the General Counsel of PNM, myself, anything in relation with Four Corners as far as I can remember.
So you don't know, as you sit there today, that PNM was found to have imprudently invested in Four Corners Power Plant?
I think you were asking me at that time what I knew, what I didn't know, and I think I answered that. And I think as of today, I probably think the best person to ask that question is Mr. Terry, because he knows the details of Four Corners. I'm sure he will be more than happy to answer to you.
I know, but I don't want to talk about PNM right now. I want to talk about Avangrid and you and what you knew and what you know now about Four Corners and PNM's imprudence in their investment in Four Corners.
I'm not aware of that.
Mr. Hearing Examiner, this is Rick Alvidrez. I need to object as mischaracterizing that there was a finding approved by the Commission to the extent there's any suggestion of that in the question of Four Corners imprudence. The hearing examiners in the 2016 rate case did make a finding which was not ultimately adopted by the Commission in that case. So the question is draws on an incorrect premise.
Mr. Nazi?
Yes, I'm asking if he was aware that there was a finding of imprudence of PNM's acquisition of Four Corners, which I believe is an accurate statement.
You're referring to the hearing examiner's finding?
That's right. And I'm also referring to the fact that there has been ordered by the Commission a prudence review in the 21-00017 UT case. And I think that this is absolutely proper to ask Mr. Zagra Velasquez about what they knew and what they didn't know about Four Corners, especially when this document says something from the chief executive of PNM. Hey, we got to tell you what we got going relative to Four Corners and the ETA.
Well, you can ask questions as long as they're not misleading. And so I think just be careful to ask to include the correct facts in your questions.
Thank you. Mr. Zagra Velasquez, as you sit there today, do you know that the question of imprudence relative to Four Corners power plant is an issue?
I know there is some discussions, on some parties that would like to have a prudent review. In another case, I don't know anything else. I think you should be asking Mr. Terry and the PNM executives about that.
Did you ever hear Mr. Apodaca assure you and Mr. Schwartz and anybody else who you were with, your financial advisors, that the ETA would trump PNM's prior agreement to engage in a prudence review of Four Corners?
I never heard that.
Did PNM tell you that upon abandonment of Four Corners, PNM will be entitled to recovery of its investment through the ETA?
I don't think I don't recall PNM saying that to me. I think, that's our conclusion, that we took ourselves, that, the abandonment, the request, for securitization,
I'm sorry, sir, that we took ourselves. And could you start that statement again?
Yeah, I think I don't recall, hearing that, from PNM executives myself directly. I think I have come to the conclusion based on our, own work that, that our recovery, is, allowed by the current legislation, and that's it. That's as far as I can go in terms of my own knowledge about that matter.
Can you go to page 28 of 139? Actually, could you go to 27 first? Do you recognize what 27 is?
27 in the same document?
Of the same document, 27 of 139. Could you please go to that? Do you see that?
Give me one second. I'm in the July 14th,
Supplemental.
57. Which one do you want me to go to? What page?
It's page 27 of 139.
Page 27.
You see that?
No, yet. But I don't know why I moved from page 26 to 28. Is that a presentation? Is that a presentation that says exit from coal generation?
Yeah, exactly.
Oh, sorry, I cannot see on the top the words. Yes, I have this page in front of me.
Okay, so could you go to the page right before that? That's an email from Chuck, meaning Charles Eldred, Executive Vice President and CFO of PNM Resources, to you. And it says, as you know, the last sentence says, as you know, our board meeting starts Thursday, and it's important to provide a perspective and the status of Project Roadrunner, right? That's what it says?
Yes.
Okay, and then the next page, right below it, is the PowerPoint presentation that PNMR sent you in December 2019 called Project Roadrunner, right? You received this.
Yes.
Okay, and the next page is the executive summary, right?
Yes.
And under the bullet Four Corners Ownership Agreement, if you go down to two bullets underneath there, it says, upon abandonment of Four Corners, PNM will be entitled to recovery of its investment through the ETA. Is that correct?
Let me just, are you in what bullet point, sorry?
It's the bullet point under Four Corners, not the first one, but the second one. This is a document that you received in December 2019.
Is what it says effective June 19, New Mexico passed ETA, that bullet point?
It's further down than that. It's 1, 2, 3, 4, 5, 6, 7, 8 bullets down from that.
Yes, yes, I see that. Yeah, I see that now. Yes.
So that's what PNM was telling you in December 2019, right?
In this document, yes.
And that's what you believed, correct?
I believe on my advisors, so I think my advisors provide me to me. So these documents always, I just, forward them to my legal advisors, they review it, and then they come back to me with their opinion, which is what I know. That's why you were asking me if I was told by them in that meeting. No, I don't recall that meeting, anything like that. They will receive information, yes, and my advisor review, and then I took, what my advisors told me. That's, what I review.
But this document was not sent to your, I mean, it might have been sent to your advisors too, but it was sent to you.
Actually, I received many things, but as soon as I receive things, I forward them for my advisors to review, not me. And once they conclude things, I sit with them.
How come this whole exit from coal generation, specifically Four Corners, was called Project Roadrunner?
Do you mind to repeat the question?
How come this project was called Project Roadrunner, the exit from coal generation?
I have no idea about that name. You should ask PNM about that.
And was it designed to satisfy the merger requirements? Can you?
No.
Sorry about that siren. Was it designed to satisfy the merger requirements by Avangrid and Iberdrola to have no coal in the portfolio pursuant to your ESG goals?
Okay. I think, first of all, the name that they put to the project, that was their decision. I think actually the first time I hear this name, okay, because I refer, to the relevant matters, on these documents, I forward them to my advisors and they come back to me with their own opinion. Second, on the specific question you are asking, I think is, the same answer I gave before. I think we did not ask PNM, you need to kick off and go and sell the stake because of our ESG. We made it very clear to them that our goals are not to own any coal facilities in operation. And that's something we have made it clear to them and to many other parties we have negotiated deals with. I think they made it clear to us before we made it clear to them that they were in the process of negotiating an exit, of the asset that they owned, the stake that they owned. So that's why they didn't do that project or they didn't do that negotiations because we told them we needed that to do so. They were doing that already and we were very happy because, we were going, to tell them that we cannot own any coal. So it matched, pretty much what they were doing with what we needed in order, to engage in merger negotiations. But we did not, based on your question, we did not force them to do that, and because we told them, they did that. No, that's not how it happened.
Okay, can you go to what is labeled as page 133 of 139? And do you see?
In this document?
Yes.
133, yes.
Actually, can you go up to 130 of 139 first?
139, sorry?
130.
130.
Of 139. So 3 pages before that. And you see the title, it says Roadrunner Investor Q&A.
130, yes.
You see that?
Yes.
Okay, now can you please go down to what is question 18, page 133 of 139? So when you reviewed these documents, did you understand that this was like a pretend Q&A that PNM had written so that they could be prepared for investor Q&As at some investor presentation?
You should ask PNM that.
Okay, and look at question 18. The question is, I noticed that having definitive agreements to exit Four Corners is a condition to closing. Why is this the case? Why is the status of agreements? What is the status of agreements? Are you in discussion with anyone currently? How confident are you that you'll be able to enter into those agreements? What are the consequences for the transactions if you cannot? Could you please read the answer?
The answer is based on preliminary discussions with potential counterparties. We are highly confident we'll be able to sign definitive agreements to exit Four Corners prior to closing of the merger transaction. As you know, earlier this year, we had already announced our intention to exit Four Corners earlier than the scheduled 2031 exit date. Exiting Four Corners also is important to Iberdrola and Avangrid in light of their no carbon fuel policy.
I'm sorry, also is important to Iberdrola and?
Avangrid in light of their no carbon fuel policies.
Is there anything about that answer that you believe to be incorrect?
No.
And sir, can you now please go to revised NEE Exhibit 5?
Okay.
So on new energy economy interrogatory 5-3, you answered that question, correct?
Sobre los datos que no sé, ¿no? Where are you now? In 5.1?
5.3, 5-3.
Yes, correct.
So I asked you.
This is Brian Haverly. I'd like to just object that all these new documents are being produced at this time. That was not what was produced back on Monday when the hearing examiner ordered that all these documents be provided for everybody to be able to download. And we're now trying to scroll through these and figure out what is in each one of these. I'm not able to determine whether these are the full documents, and I object to these new exhibits being utilized.
Nanazi?
Well, I narrowed them down, which is what PNM and the joint applicants asked over the weekend, and just put the questions that I was going to ask about. They objected at that point because they said the documents weren't complete. So now I did exactly what I was told to do in this very short time, which is to upload everything exactly as they were tendered. So these are the questions. They were not altered then. They're not altered now. The only thing that happened before was that I narrowed them to accommodate the joint applicants. Now they're saying there's too much here and we don't know if this is actually the correct document. It says right on the document, joint applicants objections and responses to NEE's 5th set. Are they saying that this is not correct, that Mr. Pedro Azagra Velasquez answered this question or these questions that I've been asking?
Mr. Hearing Examiner, if I may, I'm saying that I don't have the ability, because these should have been done on Monday, I'm learning about these all on the fly, and I don't know. I haven't had a chance to look through all of these and make sure that they are accurate and that these are our exhibits. I'm not sure. I don't have a basis one way or the other to believe that.
Okay, well, just to move things along, I'm going to allow these questions, and Mr. Haverly and Mr. Alvidrez, if overnight or soon thereafter, you find that there are any issues in terms of these documents, you can bring it up and we'll deal with it.
Okay, thank you, Mr. Hearing Examiner.
Could you please read, I'm going to ask you the question, and if you could please read your response. Is the divestiture of the Four Corners Power Plant a requirement for the proposed transaction in this matter to close? Please read your response to NEE Interrogatory 5-3, the question that I just posed.
Okay. Again, I'm not so sure if this is the document or not, but the answer that I read in what I have in front of me is that the requirement in the merger agreement is to have definitive agreements for the sale of PNM's interest in Four Corners, continue to be in full force and effect as of closing, and for PNM to have made all regulatory filings to obtain approvals for the sale of Four Corners, including abandonment and securitization.
Thank you.
I'm sorry, was the word securitization?
Yes, that is the word.
Thank you.
Could you please read your response to NEE Interrogatory number 5-4?
Do you want to ask the question or I just read the answer?
Just read the answer, please.
Let me just read the question as well so I know which one is this one. The conditions in the merger agreement are that there be a definitive agreement to sell PNM's interest and that PNM make a filing for abandonment that continues to be in full force and effect as of closing, and that the filings for approval of that sale have been submitted, including for abandonment and securitization. Avangrid has not determined whether and how a dismissal of PNM's petition to abandon its interest in Four Corners would impact the conditions in the proposed transaction.
Thank you, sir. Could you pick up with NEE Interrogatory 5-5 and start with the word Avangrid?
I object. I object to that, Mr. Hearing Examiner. If that needs to be read in, that's okay, but it needs to be the complete answer.
Yes, read the whole thing.
Okay. See response to NEE 5-4. Avangrid has not determined whether and how a denial of PNM's petition to abandon its interest in Four Corners would impact the conditions in the proposed transaction.
And could you please read your answer to NEE Interrogatory 5-6?
There is no specific provision in the merger, sorry, 5.7. Which one did you say, sorry?
5-6, please.
Oh, yeah, sorry, I moved to the next page. 1 second. Please see response to NEE 5-4. Avangrid has not determined whether and how a denial of PNM's petition for securitized financing would impact the conditions of the proposed transaction.
Can you please go to 5-9 and read your response?
5.9, yes. If the abandonment and securitization case remain pending, then the proposed transaction can close. If the abandonment and securitization is granted, then the proposed transaction can close. Avangrid has not evaluated what rights it could or would assert if the requested abandonment or securitization is denied or dismissed in whole or in part prior to closing.
And sir, could you go to the end, near the end of this document, and would you agree that you affirmed that you answered NEE interrogatories 5-2 through 5-10A, 5-15, 5-20 through 21, and 5-31?
Sorry, where do you want me to go?
To the end of the document where there's a self-affirmation that you signed that said that you affirmatively state that you know the contents thereof and that they are true and correct to the best of your knowledge and belief. And those are New Energy Economy interrogatories 5-2 through 5-10A, NEE interrogatory 5-15, NEE interrogatory 5-20 through 21, NEE interrogatory 5-31.
Yes.
Thank you. Can you please now go to revised New Energy Economy 411, which is 4B here. So if you go to our NEE Exhibit 4B, which is PNM Exhibit NEE 411, if you could please open that up.
Mr. Nassi, is that 4-11?
Yes, thank you.
You bet.
Are you there, sir?
Yeah, 1 second, because I'm getting this in a different place. Yep, I'm here now.
Okay. You recognize this document, do you not?
Yes.
This is the letter that.
Mr. Hearing Examiner, excuse me, I'm sorry, this is Rick Alvidrez. This appears to be a wholly new document, one that was not previously listed or uploaded on Monday. It's something that appears to be completely new.
It is not completely new. It was up there. It was part of the one NEE-4 with a lot of other things in it. I separated them out. This is the exact document that is in, was included before, and I'd like to pursue asking questions about this. I have very limited time.
Oh, I'm confused. Which document is this again?
This is R-NEE Exhibit 4B.
Okay. And this was a part of a previous document that had been uploaded on Monday?
Correct.
And Your Honor, I do stand corrected. There is, this document does appear, I think actually a couple of times in the first batch of documents that were attached to NEE Exhibit 4. It's a 200 plus pages of, well, actually several documents, but it was in, just included among many. So, but this document was in fact included in that batch of miscellaneous materials.
Okay, well, go ahead, Mr. Nazi.
I would like to ask if I could have 2 minutes returned to me. Could you please identify this document, Mr. Azagra Velasquez?
Yes, I think this is a letter that I sent, to the CEO of PNM.
And this is your letter, right?
I think so. Again, this is a document I cannot recall based on what I was given, last night, but, I think, it looks my letter.
Okay, and it's on Iberdrola stationery, right?
What do you mean stationary? What does it
Top
mean?
right-hand corner, it's on Iberdrola letterhead.
Yes, yes.
Okay, and if you're a little bit concerned, if this is not your letter, could you scroll through it? And do you see on page 13 of 1,333, and there's only 13 pages in this part of the document, that's your signature, is it not?
Yes, that looks my signature.
Okay, great. So could you go to page 8 of this document? And could you please read that whole paragraph B called burdensome effect standard? Could you read that, please? And read it slowly so the co-reporter could get what you're saying.
Burdensome effect standard. While we do not anticipate that as a condition for approving the transaction, any regulator would impose any condition that would constitute a burdensome effect in the relevant jurisdictions. To protect the parties from the possibility of unexpected and unwarranted requests by these regulators that would have a substantial material and adverse effect, we believe that the appropriate standard for measuring that would constitute a burdensome effect should be based on a material adverse effect on a company 50% of the size of PNM, the regulated New Mexico businesses, and would include any requirement to impose any independent or disinterested director obligations that would impact Avangrid's control over PNMR. This is still significantly in excess of the types of rate concessions we have seen in the relevant jurisdictions. Again, we need to rely upon PNMR to take primary responsibility for the regulatory approvals, and we are aligned with PNMR regarding our expectation of potential regulatory requirements. Accordingly, the size of the burdensome condition standard needs to take into account the allocation of regulatory approval, responsibility, and the size of regulatory concessions in precedent transactions in the relevant, in the relevant jurisdictions.
Okay, so in stipulation commitment 17, you have moved from your original position in this 8/25/2020 letter that Iberdrola Avangrid wouldn't allow any independent directors, correct?
I think, we accepted in Texas in the approval that we were granted to acquire, TNMP in Texas, the utility that PNMR owns in Texas, that, we will be okay with, I think, more or less 40%, 3 out of 7, board, members, being independent.
Okay, and so is it your testimony that Iberdrola Avangrid would still consider it a burdensome effect if the regulators required a majority or all independent directors?
Yes, that is correct.
Okay, can you please go to the top of page 9?
Of this document?
Yes, And this is,
One second. Page 9.
okay, it's just the very next page.
Yep.
Okay, and it says, Iberdrola and Avangrid recognize the value of local management in providing a direct connection between their utilities and the communities they serve, and the expertise that local management provides with respect to the individual businesses and issues they face. For example, all utility operated decisions are determined by the officers and directors at the utility level. Consistent with this approach, we intend to maintain the local management decision-making structure at PNMR, just as we have done in other states. Is that a statement that you made on August 25th, 2020? And is it correct today?
I think the letter that I'm reading is different from what you said, or I'm looking at the wrong page. What page? You're in page 9 of the letter?
Yes.
At the top, right?
Yes.
Let me just read the one. It's Iberdrola's and Avangrid's businesses are organized by geographical areas.
Sorry, sir, you'll have to slow down.
Please don't read it. Please don't read it out loud. Just read it to yourself and tell me if that first part of the paragraph, which I just read, was accurate on August 25th, 2020, and it's accurate today.
Yes, what I'm reading is correct.
Okay, thank you. Now, at the bottom of page 9, it's under a paragraph entitled Focus on ESG. Do you see that?
Yes.
Okay, you discuss Iberdrola's Avangrid's focus on ESG that doesn't allow Iberdrola and Avangrid to have any investments in coal assets, correct?
Correct.
And that was true in August of 2020, and it's still true today, right?
Yes, we have the same, vision right now in owning, stakes or assets of certain types.
Thank you. Can you please now turn to revised exhibit number 23.
Okay.
Okay. So, Mr. Azagra Velasquez, you answered CCAE interrogatory number 1-1, correct?
Yes.
Okay. Can you look at the very bottom of this document? I only wanted to ask you about this one question. Can you look at the bottom of this document and you see a self-affirmation, and it says that you answered CCAE interrogatory number 1, you knew the contents thereof, and that they are true and correct to the best of your knowledge. Do you see that self-affirmation?
I cannot see that in this document that I have. If you point to me the page.
It's very, very close.
Yes. Well, I see Ron Darnell.
I know. So now go down to where your name is. Ron Darnell is first. Yes. You're second.
I have it now. Yes.
Okay, and you see that CCAE 1. You said that the contents that you responded to were true and correct.
1-1.
Yes. Okay. Now, if you could please go to exhibit number, this is just the regular one, NEE Exhibit 21, not revised. Are you there?
Yes, I'm getting the document. Okay.
So this is an Albuquerque Journal article with your lovely picture there. And at some point in late July, you gave an interview to the Albuquerque Journal, and your statements are included in an article entitled Iberdrola Execs addresses, or Iberdrola Exec, excuse me, addresses merger criticism. Do you see that?
Yes.
And you did in fact give an interview to the Albuquerque Journal, right?
Yes, I did.
Okay. Could you look at the last two paragraphs on page 1?
Yes.
Okay, it says, New Mexico's abundant wind and solar resources provide immense opportunities to not only accelerate that clean energy transition, but to convert the state into a central hub to supply renewable electricity throughout the West, creating hundreds of jobs in the process with huge benefits for the local economy, he said. Then it says, quote, New Mexico is abundant with renewable resources and has a carbon commitment that requires substantial investment, and we can assist the state to achieve those goals, Azagra Velasquez said. New Mexico has substantial growth opportunity that will benefit its residents and PNM customers. New Mexico has not yet hit its potential, but we believe it will. Is that an accurate summation of what you told the reporter? And in the last paragraph, are you quoted accurately?
I think he took notes of what I said, so I cannot confirm that this is exactly what I said. But in general terms, I think, it summarizes more or less what I said.
And do you believe that those two paragraphs are true and accurate today?
Something in particular, or do you want me to go through each of the sentences and comment on them?
No, I want you to just tell me if the last two paragraphs that I just read to you are true and accurate. Do you believe them?
In general terms, yes. If I go through the specific words, I make precise, what it says to be more accurate. So that's the reason why I'm happy to go through it and tell you, what is 100% and what is, something perhaps I can explain better.
Okay, I'm not asking you to revise it, but are these two paragraphs that I asked you about, are they true? Do you believe them?
I think that's what I answered to you. I think in general terms, yes. If you want me to confirm every word, then I'm happy to go through it and tell you if I would, make some additional comments to the words said there.
On the next page, can you please read in the middle of that page that begins with the word Iberdrola? It's right in the middle under local strategy. Could you just read that paragraph and the next one?
Yeah, Iberdrola is now participating in negotiations and regulatory
I'm sorry,
proceedings.
sir, if you could slow down a little bit. Iberdrola?
Iberdrola is now participating in negotiations and regulatory proceedings, but its direct involvement here will end once the merger is done. Azagra Velasquez personally manages Iberdrola's mergers and acquisitions across the globe.
Can you read the next one?
I'm the one with expertise needed for these deals, he said. We can't have subsidiaries like Avangrid buying companies. That's a higher level of strategic management. I'm here now meeting with people, but once we close, I'm out of here, and it will be local people running utility operations and projects.
Is that an accurate statement?
I think, this one, I'm more than happy to explain what actually I said. I think, any holding company that owns utilities, and this is how it was explained, is in charge of the acquisitions of their subsidiaries. You don't have subsidiaries that they decide on their own to merge or to acquire. They make proposals. Those are strategic options, strategic transactions. The example that I gave about my involvement is I have been in charge, and appointed by the board to take care of the regulatory process. That's what I have done in all the previous transactions in the last 20 years that Iberdrola has done globally. Specifically in the US, I was in charge of all the processes in New York, Connecticut, Maine, and Massachusetts several times in some of them. And therefore, the example that I gave was, when the parent company, Iberdrola gets involved and when not. And I think, there is a clear, separation when the transactions are involved. I definitely work, with, my Avangrid team. I'm working with the CEO. I'm working, with the president and deputy CEO. I'm working with the general counsel. I'm working with the people from networks. So there is a team. I happen to be the person leading because of my experience and my track record. It's also because of the size. I think I explained, in this interview, we're speaking an 8 billion, company. So you expect, the whole group, to be on top of, such a material decision because of the amount. That is the background. And then what I said was, once the transaction itself, is over, those of us that, we have different roles, continue with those roles. I think the local management is the one now to continue with the local operations.
And basically what you're saying there is you come in for the acquisition, but once, if the merger is approved, then Iberdrola is hands off and local management controls. Is that right?
Once we close the transaction, as it has been the case with every utility, is the local utility to run their operations, with the management of the local utility.
Okay, thank you. Could you please turn to NEE exhibit, not revised, just NEE exhibit 19.
Okay.
Okay, so do you recognize this document?
Yes.
This is the affidavit you gave in support of the position of alleged conflict of interest, correct?
That is correct.
It states that the location on page 1 is from the Kingdom in Spain. Were you in Spain when you affirmed the contents therein?
Sorry, where are you right now in the page 1? In what line?
There is no lines here. It just says that the Kingdom of Spain, under your name, affidavit of Pedro Azagra Velasquez, and then it says Kingdom of Spain. Were you in Spain when you affirmed the contents therein?
I think I was. If I can confirm the date, then I will be able to confirm. That's July 30th. I don't remember now by heart if I was, already in Spain, but probably. But I don't remember now by heart.
Well, if you weren't in Spain, why does it say Kingdom of Spain in it?
Maybe because that's my location, that's where I'm based. Not so much because I was or not at that time.
How many days before?
I object to this line of questioning. The affidavit has said what it says. I don't understand what Ms. Manassi is trying to do here. The affidavit speaks for itself.
Mr. Nazzi?
This is a sworn statement by a chief witness in this case. I can ask him about his own affidavit.
Overruled.
Sir, this was about 12 days ago. Do you remember if you were in Spain or not?
I think I've been back and forth in the last 4 weeks or 6 weeks since I was allowed by the US government again to have an exception and being able to travel at least 4 or 5 times. So I cannot remember any longer, where I have been.
Mr. Examiner, I also object on the fact that this is regarding an affidavit regarding the conflict of interest issue that you have already ruled on, and I believe this has been disposed of. There's nothing.
I'm sorry, I believe this has
been ruled on by the hearing examiner. While there is a motion pending for reconsideration, the hearing examiner has ruled on this. I'm trying to understand why we're in an affidavit regarding something that has been already determined by the hearing examiner. I believe it is irrelevant.
Mr. Nazzi?
Yeah, this is a sworn statement by an opposing party. I believe I can ask him questions about it. It was just a couple of days ago when he allegedly wrote this and signed this. And I think it goes to, again, the material and relevant conduct of Avangrid and Iberdrola that this is just the beginning of this whole area of questioning.
Yeah, in my order, I think it was August 6th, I ruled that that facts relevant to this issue would be, facts related to this issue would be relevant in this case. And so I'm allowing this questioning and overruling the objection.
When were you contacted by your attorney about signing an affidavit, about signing this affidavit?
Objection, attorney-client privilege, Your Honor.
Sustained.
In paragraphs 2, 3, and 4, 5, 6, and 7, it states Iberdrola retained or understood certain things. Does that mean you understood those things and you retained?
Iberdrola. I don't retain myself personally, but I represent Iberdrola. But
So
who retains is Iberdrola.
Okay, but you, on behalf of Iberdrola, retained Marcus Real and the firm of Robles, Real, and Anaya, correct?
There is we have a very strong, contract, procedure. Once, I was recommended and advised to get additional support in the transaction. I think, I put it, in the internal process. So basically, I need to go, through my compliance department. So they do the review if this is the right law firm and the right, advisor to be used. I have, the control people and the legal department to review that as well. I need to get a budget and then I approve it. So it's not just Pedro Asagra, who decides yes in a second. I am the one proposing that. And there is a whole process. And then, there is, an engagement with this advisor and as with any other one that we have.
So I know that thank you for that explanation that Iberdrola has these controls to determine if certain acquisitions are appropriate, but you're the only witness from Iberdrola who signed this affidavit, right?
Yes, that is correct.
Okay. You, on behalf of Iberdrola, hired Marcus Real to negotiate with Mr. Balderas, the New Mexico Attorney General, correct?
Objection misstates the facts.
Sustained.
Did you not hire Mr. Real to facilitate communication in this case?
Objection misstates what Mr. Zagra just said about how the retention process went.
Sustained.
If Mr. Hearing Examiner, I can prove this up in the next couple of documents, can I revisit the question and answer that I just posed?
You can try.
Okay, thank you. Did you recommend to Iberdrola that you hire Marcus Real?
I proposed to hire his law firm.
Right. And did you propose to hire him to facilitate communication to result in a settlement and the merger?
We hired, this law firm to help us, to negotiate, the settlement that we were negotiating at that time.
And that included to facilitate communication with the New Mexico Attorney General and his staff.
I would not say to facilitate. I think it's just to advise me and to engage in the negotiations with the different parties, that the law firm, could help us, to negotiate with in the settlement discussions.
And you understood that Mr. Rael was concurrently working for the New Mexico Attorney General's office?
Not at that time. I became aware of that, later.
Could you look at your affidavit right here? And
Yeah.
on paragraph 4, it says, at the time Iberdrola retained Robles law firm, Marcus Rael Jr. informed Iberdrola that the Robles law firm represented in various unrelated litigation matters multiple governmental entities, including the Bernalillo County Board of County Commissioners and the state of New Mexico, and claims initiated by the New Mexico Attorney General's office.
Yes, that is correct. Iberdrola doesn't mean me. I think, I have probably 30 or 40.
Sorry, sir, you're breaking up. Can you start your answer again, please?
Yes, I think, this paragraph is very simple to be understood. It doesn't mean Pedro, it means Iberdrola. Iberdrola includes also its advisors. They do their homework. They review those law firms we want to hire and other advisors. I'm not the one to review that. I think, I just got from them an okay that this is the right law firm we should be hiring. I may have now 30, 40, or 60, or 70 engagements with different law firms. I'm not the one doing the due diligence on each of them. It is recently where I became aware of what it says here. And my advisors reviewed that. They were the ones that concluded there was no conflict of interest at that time, because, and I can confirm that, I'm very used to have legal advisors working for me in a matter with, another party, and the same advisor is helping that party in a totally different matter. That's very common, with legal advisors, in many, many places, and even, auditing firms and other advisors. So that's why this opinion is what the teams and my advisors did at that time. I just got to know that this was the recommended one, and that's what I proposed. This is recently when I have been aware myself. Now I'm speaking about Pedro Azagra, that he was working for other mandates for other people, etc. But not at that time. I didn't need to have those details.
So are you saying that this affidavit and the self-affirmation that says that you believe the statements are true and correct based on your personal knowledge is not correct?
No,
Objection.
I'm not saying that.
States the witness's statements.
Sustained.
So are you now saying to us that you didn't know that the Robles law firm represented the New Mexico Attorney General when you hired, when you and Iberdrola, you on behalf of Iberdrola, hired Mr. Rael?
Objection, misstatement of the prior testimony.
Sustained.
Did you know that Mr. Rael was working for the New Mexico Attorney General and Bernalillo County when you recommended that he be hired by Iberdrola?
Objection, asked and answered.
Overruled.
I think I'm going to answer in the same way. At the moment of recommending, just to make it very clear, my teams includes external advisors, propose to me additional advisors every day. And I just need that they have done their homework, they have reviewed things. So Pedro Azagra, when we propose to have another advisor, I don't go into those details. My teams take care of that. So I only have to sign a budget. I just need to, forward, that to the right people, but I don't need to go into the details. Other advisors and teams take care of that. I have become aware that, he was, this lawyer and this law firm were working in unrelated matters to this transaction and this regulatory process, which is the important thing for me, because that's what happens many times, very recently, okay? Not at the time of engaging with him. Of course, I became aware that, he had worked in energy process, matters, in renewables, in transmission and other matters. I became aware of that, and that it was, a good law firm with a lot of background in different things. But that specific question, I don't need to have that explanation to me at that time. I have become aware recently because of these matters that have been dealt with the hearing examiner.
So can you just answer me yes or no? Did you know when you recommended that Iberdrola hire Mr. Royale, that Mr. Royale was working for the New Mexico Attorney General and for Bernalillo County?
No. When I recommended this firm, my team took care of 100% of the process. I did not even ask or got one feedback on this law firm. That's not what, I have, time to do. My teams do that. After all the things that I have had to do now because of the hearing examiner request, yes, I have become 100% involved in knowing a lot of things. But at that time, no, I don't need to know that. They have to take care of that themselves.
Thank you. Could you go to the revised New Energy Economy 18?
Ms. Nanazi, just to remind you, you have 15 minutes.
Thank you.
Revised Exhibit 18?
Yes.
Yes, okay.
On August 2nd, you answered all the questions posed as part of New Energy Economy Exhibit 18, correct?
Yes.
And if you could just look really quickly, scroll down from 18.1, 18.2, 18.3, 18.4, 18.5, 18.6, 7, 8, 9, 10, 11, 12, 13, 14. You answered all those questions, correct?
I have, sorry, but this document, again, is not one that I'm comfortable with versus last night. So I have 18.1, the answer is yes. If this is the document that I should have. 18.2, yes.
Okay, sir, I only have 15 minutes left and I have so many questions. So if you could go down to the end, to the self-affirmation, could you look at that? It says there that you affirm that you answered honestly, truly and correctly to the best of your knowledge, NEE interrogatories 8.1 through 8.14. Is that correct?
I 18.1 through 18.14. Yes, I have it in front of me.
Okay, thank you. And could you also look at 18, can you look at 18.14? And it says at the bottom of 18.14, subject to and without waiving the foregoing out objections, please see JA exhibits NEE 18-14A, add, I think that should have said and, NEE 18-14B. Do you see that?
I'm sorry, Mrs. Nanasi, but you are referring to 18.14?
Yes.
Yes, okay, yes, I'm here.
You see that?
Yes. Should I read it?
No, I just read it. I read it. The
Sorry,
subject.
but I'm trying to get this
There.
document in front of me, and it's not, because it has been filed recently. I'm going very slowly to move this.
Okay, so what that means is that there are exhibits that are attached to the 18th set, and those are 18-14A and B, right?
Yes. Subject to and without waiving the foregoing objections, please see JXTV NEE 1814A and NEE 1814B.
Okay, can you go to 18-4? And we reference here in the question, the New Mexico areas 4-1. And it says, please state as to each of the meetings occurring on each of the following dates, who else was present besides Rael and the Attorney General, how long the meeting lasted, where did the meeting occur, and provide a summary of the substance of the meetings and state whether any documents memorialize the meetings, and if so, who has them. And so you answered that question, correct?
Yes, I have it in front of me, 18-4.
Okay, and the very last part of it, it says all meetings were either by video conference or telephone, correct?
Yes, the list of meetings here, to my knowledge, it was by video conference or telephone.
Okay, so now can you go back to revised 18 and now look at 18A?
18-8.
18A, that's the exhibit attached to those interrogatories.
18-8, yes.
Okay, this is,
1 second.
this is a letter from Marcus Rael to you, dated March 10th, 2021, on Robles, Rael, and Anaya stationery, tendered via email. Do you see that?
Yes.
Okay. Then under it, it says scope of representation. You see that?
Yes.
And could you go to the bottom of that page? It was agreed to by Iberdrola representatives at your behest. Martin, S-A-I-T-U-A, next word I-R-I-B-A-R, signed it on March 15th, 2021, correct?
I'm sorry, but where are you?
At the end of the letter, sir, at the end of the professional service contract.
At the end of the letter? Yeah, sorry. Yeah, okay.
Okay, now, okay, good. So can you now go back to the first page?
Sorry, in the end of the letter, what do you say, just for me to understand you?
I said that Martin Saitua Irabar signed it as a Iberdrola representative as part of your exhibit in answer to 18-14 on March 15th. He signed that.
He signed that, yeah, I don't see the March 15th, but.
It's right there above his signature. It just says
Oh,
15.
yeah. Yeah,
Okay.
sorry.
Okay.
Yes.
Now, could you go back to the first page?
Yes.
Okay. Does the scope of representation, you see where I am, the first page?
Yes.
It says, we have been engaged to represent Iberdrola and its affiliate Avangrid for the purpose of consulting in the state of New Mexico. To that end, we will help facilitate communications between Avangrid and various public and non-public entities as directed by Iberdrola or Avangrid. We will also communicate legal positions to the same entities or individuals as directed. As discussed, we will also develop a strategy to help facilitate Avangrid's purchase of PNM and Texas New Mexico Power. We will not undertake any lobbying activity. Is that an accurate reading of your agreement between Marcus Rial and Iberdrola?
Yeah, that's what, it says here.
Okay, then the term of this agreement shall be effective beginning February 19th, 2021 through completion of acquisition. Is that also correct?
Yeah, that's what it says here.
Then it says the fees and billing statements. Iberdrola shall pay partners an hourly fee of $400, associates an hourly fee of $350, and $95 for paralegals. Is that correct?
That's what it says in the document.
Okay, then underneath that, it says, unless otherwise agreed in writing by you, the fees may amount up to $250,000, including any incurred expenses. Is that correct?
That is what it says here.
Okay. Can you please go now to 18B?
So Nazi, you got 5 minutes.
This is Mr. Marks. I saw an email from Mr. Borman. He was trying to get back in. Apologize for interrupting, but
he's back in.
Mr. Azagra Velasquez, were you made aware that New Energy Economy and a number of others filed a complaint against Mr. Rial and Mr. Balderas with the State Ethics Commission, with the State Auditor, and the New Mexico Disciplinary Board of the Supreme Court on July 15th, 2021?
I know there was a filing. I don't remember if it was to all those entities that you mentioned, but I think I know there was a filing done by you.
Okay, and you know that that took place on July 15th, 2021, correct?
Yes.
Okay, if you could look at Exhibit NEE 18-14B, that's before you. This is an amendment to the professional service agreement. Is that right?
Yes. Let me just check.
This is an exhibit to your answer to NEE interrogatory 18, correct?
This is an amendment. This is an amendment contract. What I don't understand you say about my interrogatory.
This is your exhibit to your interrogatory answer.
Oh, yes, it's exhibit 18-14B.
This was on July 17th, 2021. That's what it says there, right?
Yes, that's the date of signing this.
And there's no letterhead here, is there?
You don't need to have a letterhead.
Okay, and the purpose of this amendment was to increase the cap fee of the professional services agreement from $250,000 to $350,000. Is that correct?
That is correct. Mr. Hearing Examiner, I would just like to retain my ability to object because I'm not sure that this was a document that was produced on Monday, and because I don't remember seeing this, so I'd like to retain my ability to object on any type of mission or move to strike any of this testimony because I have no information that this was actually uploaded on Monday.
Okay, thank you. Please do not take up any more of my time.
You have that right, Mr. Harmon.
So Mr. Azagra Velasquez, how come the cap was increased on July 17th, 2021?
Objection, attorney-client privilege, Mr. Hearing Examiner.
overruled?
I think it's a very simple answer. When we have, mandates with a lot of advisors, we set up an initial budget, and this is an internal control issue. Once those advisors, because of the time they have spent working for us, go above the agreed amounts, the only way for us to continue working with those advisors is to revise the budget. So you see the date. This is coming from long before. Okay, this is an internal process that we need to get going as soon as we approaching those amounts. So my teams, I'm sure, they identified because they ask the advisors what is the amount that they are spending, every now and then. And once we are approaching that amount, if we want to, to continue engaging with that advisor, we need to request another budget. So this is just the result of the additional budget requested. I think that budget, I'm sure, is days and weeks before. So this letter comes out in a date when finally we have the budget approved. And I'm sure, my team communicated to the advisor, until I don't have the budget, we cannot go above the cap. So this letter is dated July 17th. But, my team, to be able to sign this letter, and I think if I go, to the people that signed, I clearly had the feeling that some people were on holidays because of, who was signing, by the control department. So I think, and that's probably the reason why you don't have the letterhead, because, some people were on holidays at that time. But I think, or were not able to sign, and that's why you got somebody else to sign, and not the initial person, which, by the way, I think he was retiring. So there may be some reasons, behind that as well. But this letter, dated July 17th, is the result of the process to get an updated budget because we went above the limit days and weeks before. So it's not something that starts on that day. It's the result of the work being done before.
Okay, Ms. Nanazzi, your time's up.
Mr. Hearing-Examiner, can I please trade some time that I have? I'll trade all of my time from Ms. Lapson to continue this.
Mr. Hearing-Examiner, I just object to this. This whole now trading more time and just trying to prolong the discussions with Mr. Azagra. She had time. She told you how much time she needed. Then she increased that time once already. Now she's trying to increase it again. I object to this.
We're going to take a 15-minute break now, and we'll discuss it when we come back. We'll be back taking a recess until 10 after 3.
Thank you so much.
Thank you.
Mr. Haverly?
Yes, Mr. Lee.
That was you doing all the talking, right?
That was. I apologize, Mr. Lee. I got.
I know. You're in the heat of battle. I get it.
I do apologize. It makes your life harder, and I'm sorry for that, sir.
No problem.
Hey, David, are you ready to get back on the record?
Yes, sir.
Okay. Let's see. Ms. Nanazia, I'll allow you the with 50 minutes additional, and take that away from Ms. Lapson.
Thank you so much, sir. Mr. Zagra Velasquez, could you please go back to the revised new energy economy exhibit 18? Those were the objections and responses by you.
Okay.
You answered these questions on August 2nd, 2021, just 9 days ago, correct?
Second of August, yes.
Okay, and in your answer to 18.1, you said that Iberdrola has not paid any amount to Marcus Royale or his law firm. Do you see that?
Yes, I can see that 18.1, subject and without waiving the foreign objections, joint applicants state that as of today's
I'm
date.
sorry, sir. I'm sorry, sir.
Sorry.
You're breaking up.
Mr. Lee, sorry about that. I'm going to look at the speaker. Subject to and without waiving the foregoing objections, joint applicants state that as of today's date, Iberdrola has not paid any amount to Marcus Real or his law firm.
Since August 2nd, 2021, have you paid Marcus Royale any money?
I'm not aware of that information. I'm happy to provide that information if needed, but I don't have, that information with me.
Okay. Now, if you could go to 18-4, this is the 18 meetings that you listed that Marcus Royale had with the New Mexico Attorney General and his staff. And is that correct?
I think.
Okay. And as
I think there were other parties as well in some of the meetings or in all the meetings, but
okay.
Do you want me to the answer or no need?
No, that's fine. But and you say here that all meetings were either by video conference or telephone, right?
That's what it says at the bottom of the response.
Okay. Could you please turn to revised new energy economy exhibit 7?
Revised exhibit 7, yes.
Okay. And could you go all the way down to where it says self-affirmation? And it says here that you knew that the contents were true for NEE Interactory 7.1 through 7.5. Is that correct?
Yeah, just give me 1 second. I'm getting to the page. Sorry again that this document doesn't sound to me like the ones I had. I need to find it. Yes, it says NEE interrogatories 7-1 through 7-5, dated April 5th. Yep, that's
Okay.
me.
And there's only 5 questions in this interrogatory set, right? And so you provided all the answers to that, right?
Would you like me to go one by one? 7-1, yes, that's me. 7-2, you want me to read the answers?
No, I just want to know if you,
Okay, sorry. Yeah,
there's only
yes.
5,
Yes, 7-2 is also
there's
mine.
only 5 questions. And
Yes.
there's only 5 questions and you answered all of them.
Yeah, the 5 of them are my answers, yes, my questions, the answers to the questions.
Can you, thank you. Could you go to revised NEE Exhibit 7A, which is the supplemental response to NEE 7?
Okay.
And here under 7.1,
Just to confirm, NEE Exhibit 7A.
right?
Yes, okay, please.
And here you confirm under your first supplemental response that Iberdrola hired Mr. Rael as legal counsel. Mr. Rael was retained on March 10th, 2021. His rate is $400 per hour and Iberdrola is paying this expense, correct?
But if you don't mind to tell me where you are, because I'm opening this document now for the first time. Where are you in the document, sorry?
7.1.
Just one second.
Supplemental.
Oh, yes, I have it here. First supplemental response. Iberdrola has retained Mr. Real as legal counsel. Mr. Real was retained on March 10th, 2021. His rate is $400 per hour. Iberdrola SA is paying this expense.
I'm sorry to ask you this, but could you go back to revised NEE Exhibit 7? We were just there, and I need to ask you a question about 7.3.
Yep.
This is your answer, which you've already said that you answered truly and correctly.
7.3.
Could you read your response to 7.3, which is at the
Yes.
top of page 4 of 6?
Yes, 7.3. My response is the joint applicants generally understand that Mr. Rael has represented the New Mexico Attorney General Office as well as other governmental clients in New Mexico and related to this merger proceeding or any other commission proceeding, but joint applicants do not know the details of the requested information.
Okay, and that was your answer that you affirmed was true and correct on April 4th, 2021, correct?
The date of this was? Yes.
Okay, can you go to the next page, the very next page? Actually, it's 3 pages later. It's page 6 of 6. Do you see there's a bunch of attorneys' addresses and names on there? Do you see that?
Just give me 1 second. Page 6 of 6?
Yes.
This is Brian Haverly, Stacy Goodwin, that page?
Yes, that
Yes.
page. So do you see sort of like almost directly in the middle of that page, there's a number, a letter there, and then a number there. What is that?
I don't know what you mean.
It says GCG number 527839V3. Do you see that?
Yes, yes, on the right side, yes.
What is that?
I have no idea.
Can we go back to your exhibit, your affidavit, which is NEE exhibit, regular exhibit, 19.
Yeah, okay, 19.
At the bottom of that exhibit, the very bottom, under your signature, it has a stamp there, or it has some numbers and letters there. And that is GCG, numerical, the number sign, 528655. Do you see that?
Yes,
Do you know what that is?
I don't know what that is.
Okay. Can you go please to revised NEE exhibit 22?
One second. I'm in NEE exhibit 22. Where would you like me to go?
Revised New Energy Economy Exhibit 22. They're
Yes.
your answers to, mostly your answers to New Mexico areas number 4.
Which one did you want me, or one?
I just want you to go to the very end where your self-affirmation is and see that you answered New Mexico area interrogatory 4-1 and 4-3.
One second.
See that?
One second. I'm having Ron Darnell. One second.
You're right before Ron Darnell.
Yep, just give me 1 second. Yes, I can see that. Interrogatory NM area 4-1, interrogatory NM area 4-3, and it's 28th of May, 2021, and that's me.
Okay, good. Now, there was a supplement to this. And so if you could go to revised NEE exhibit 22A, that's where you actually provide some responses to the New Mexico area.
Objection, argumentative.
Overruled.
And you see, these are your first supplemental responses on June 24th, 2021. And that's to NEE, that's to NM area 4-1 and 4-3. And at the bottom is your self-affirmation. Do you see that?
I'm trying my best to run. I have NMR interrogatory 4-1 to 4-3, supplemental June 24, 2021.
You got it.
That's the one?
That's the one, you got it. And you see that at the end is your self-affirmation saying that you answered those truly and correctly?
Yes, that's this page.
Okay, so one of the questions is about Marcus Rael on, it's 4 of 11, and it asks you, tell me what, the question is about what the meetings that Marcus Rael had. And there you list them. Those are the meetings that Marcus Rael had up till June 24th when you answered this.
Yep, sorry, but which question are you in now?
It's your supplemental answer to 4-1 and
1 second, 4-1. Yes, okay, sorry.
And on page 5, you list the times that Mr. Rael met with the New Mexico Attorney General's office, and you list, and you say here at the end of that list, additionally, Mr. Rael attended a scheduled meeting with Ken Martinez, the county attorney for Bernalillo County, on March 10th. Mr. Rael also had a number of telephone conferences with Mr. Martinez. Mr. Martinez was advised of and aware of his right to have his regulatory counsel present for the discussions. You see that?
You are in page, 1 second, page 5 of 11, out of 11?
Yes.
Okay, yes, sorry, but this document, again, is different from the one I had last night. So it's moving and I cannot very easily approach it. Yes, I have it in front of me.
So if this is as of June 24th, the activities that Mr. Rael did on your behalf for Avangrid as well, at $400 an hour, let's say he spent 2 hours at each one of these meetings, including the meeting with Ken Martinez, that would come to about $28,000.
Objection, speculation.
How
Sustained.
how much time did Mr. Rael spend at each one of these meetings? Do you know?
I don't know. I know how much time he spent with me.
Okay. And is it recorded here?
I think these are meetings, with the parties, not with me.
Okay. So how about if I ask you if Mr. Rael spent 10 hours at each one of these meetings, that would come to $180,000, right?
Brian Haverly, objection, speculation.
Sustained.
What was the reason that you increased the cap from Mr. Rael's contract from $250,000 to $350,000 on July 17th on behalf of Avangrid and Iberdrola?
Objection, asked and answered.
Sustained.
Did you meet with Mayor Keller?
Yes, I met with him recently. Meeting in person. I spoke with him before, but in person I met recently in the last 4 weeks. Again, my memory cannot tell you when, but I met with him in, I think 2 weeks ago or 3 weeks ago or something like that.
And when you met with him, was Ms. Jane Yee, counsel for City of Albuquerque, present
No, she was not.
on either occasion?
I only met once with the mayor in person. I think there were two other colleagues of the mayor, two people from his team, but I don't remember their titles. I think Lawrence and somebody else, but I don't remember their names right now.
And this was only last week or a couple of weeks ago?
I think it was 2 weeks ago, more or less. Again, so much back and forth that I sometimes I don't know where I am. But, I met with him recently.
So, sir, could you look at the page 5 of 11 right there where we just were? And it says here that Ms. Conway attended a meeting with Albuquerque Mayor Keller and Pedro Azagra Velasquez via Zoom on November 19th, 2020.
I said to you in person. In person. I was very precise. First time I met in person with the mayor was 2 weeks ago, more or less.
Okay, and Ms. Jane Yee was not present when you met with him via Zoom on November 19th, 2020, was she?
I don't remember that. I remember meeting with, his attorney. Sorry, not meeting because I also, I'm not sure I have met her yet, but I have spoken with her and video with what in many of the settlement discussions, she was there, and I had also a video with her, I think, but I don't remember, if she was in that Zoom.
Okay, sir, could you please go to revised NEE Exhibit 16?
Okay, I am right now in revised NEE Exhibit 16. Yes, I'm here.
Okay, could you go all the way down to the self-affirmation?
Yes, NEE interrogatories 16-1 through 16-17, NEE interrogatories 16-20 through 16-21, NEE interrogatory 16-24, NEE interrogatory 16-30 through 16-35, dated July 6th by me.
Okay, and you answered those interrogatories truly and correctly, correct?
To my best knowledge, yes, yes.
And can you go to interrogatory, revised NEE interrogatory 16A?
16.
Oh, no, sorry. 16B.
16B. Is that a different one? Okay. Just give us a second. Okay, 16B, yes.
And can you go all the way down to the self-affirmation that you provided?
This one is, I got it quickly. Interrogatory NEE 16-4, supplemental July 26, 2021. Interrogatory NEE 16-6, supplemental July 26, 2021. Interrogatories NEE 16-23 through 16-25, supplemental July 26, 2021, dated 26th of July, 2021. Yeah, that's me.
Okay, and now could you go to revised NEE Exhibit 16D?
Yeah, this is the Baker McKinsey report.
So, sir, Iberdrola conducted 2 internal audits regarding the CENYT investigation. Is that right?
Are you referring to this document in any specific, in general?
I'm going to get to this document in a minute, but I want to ask you, did Iberdrola conduct 2 internal audits regarding CENT?
Oh, Senate. Sorry, I didn't understand, that word. Sorry about that. Yes, Iberdrola, did, what is required internally in terms of, the compliance review, and we had also, there were different other reviews. So there were many reviews done internally.
Okay, and both those internal reviews found nothing wrong with Iberdrola's corporate governance. Is that right?
I think what the internal, findings were clear, that they didn't find any wrongdoing in terms of, how, it was conducted, those, actions, and, that they didn't found anything wrongdoing, with the company that you refer to.
Okay, and Iberdrola paid PricewaterhouseCoopers and Baker and McKenzie to do different reports regarding CENT investigation.
I think, as soon as anything like that happens, my firm takes those things extremely seriously. It doesn't matter whether, the amount is big or small, it's a question of reputation. So anytime that has happened in our group, we take immediate actions. I think in this case, there are always 2 types of actions, the internal one and the external ones. I think, you have already commented on the internal ones. That was not enough. We always also refer to external sources. So we took, a #1 auditing firm, specialized in forensic reviews like PwC, by the way, a non-Spanish company. And then we also, took, an American law firm, Baker McKinsey, for both of them to perform their reviews of the same matter, because that's, what we also need because of our corporate governance, in order to, to be comfortable that the findings are not just internal, but also external.
Thank you, but you paid both PricewaterhouseCoopers and Baker McKenzie to do those. Is that right? Iberdrola paid them.
You have to hire them, and they need to be compensated to do so.
Yes. Okay, so under the 2, where it says brief summary of the purpose of part 17, the first line of the second paragraph says, the facts under investigation could constitute crimes of bribery and discovery and disclosure of secrets. Is that right? That's what they were investigating.
They investigate, investigators in Spain, they investigate, potential, but there is nothing determined and nobody has been, charged, with any of those matters. I think the findings of all the reports is that there are no basis for Iberdrola's subsidiary or Iberdrola's executive, to be considered under those specific, examples you are providing.
Could you go to page 8 of that same document? And in the middle of the first paragraph, it says, after the bold part where it says 29,500 euros, it says, at which time Mr. Valerio, that's
Just give me 1 second, because you're in page 8.
Yes.
Okay, yeah, I'm here.
After the bold part where it says 29,500 euros, it says, at which time Mr. Valerio, Villerejo, was an active police officer. which would justify, according to the prosecution, that his summons to the proceeding, that's with an S on it, is for bribery. Note that the crime of bribery does not generate damages that can be claimed by way of civil liability. Do you see that?
Yes.
What is your understanding of the last line I read from the report?
Objection calls for a legal conclusion.
Ms. Nanazi?
I'm not asking for a legal conclusion. I'm asking for him, the only person from Iberdrola who's testifying here, to explain what he thinks that last line means. Note that the crime of bribery does not generate damages that can be claimed by way of civil liability.
Mr. Haynes, Brian Haverly, if I could respond.
I'm sorry,
Yes.
I didn't hear you, Mr. Haverly. Go ahead.
Oh, I apologize, Mr. Lee. This is Brian Haverly, if I may respond to that statement.
Yes, go ahead.
Yes, Mr. Hearing Examiner, this is a document produced by a prominent law firm, and it is talking about legal issues in Spain. That asking Mr. Azagra what these things mean is what the lawyers are saying is asking for a legal conclusion.
Sustained.
Well, does it mean that because bribery is a specific intent criminal offense, that Iberdrola or one of Iberdrola's subsidiaries is relieved from civil liability?
Brian Haverly, objection calls for a legal conclusion.
Sustained.
If I may, Mr. Hearing Examiner, I believe that what they're saying to this commission is that there is no wrongdoing by Iberdrola. And so I think that he's using this Baker McKenzie and the PricewaterhouseCoopers House audit to say that that's in fact the truth. And so I'm probing that.
So, Mr. Hearing Examiner, this was produced in discovery and also at the request of the commission. Iberdrola did not rely on this in terms of anything that they put in evidence into this case. These, again, are legal documents. She just asked specific intent, which is a legal term. So I'm going to strenuously object that my witness be asked these questions about what this document means that's been produced by Baker McKenzie.
I agree, sustained.
Okay, can you please go to revised Exhibit 12.
Sorry, exhibit what?
Revised NEE Exhibit 12.
12, thank you. Okay, revised NE Exhibit 12.
Sir, these are a number of questions here. Could you go about Iberdrola's subsidiaries who are accused of fraud and/or corruption or market manipulation that you answered? Could you go to the self-affirmation and see that you answered NEE interrogatories 12, 1 through 4 to the best of your knowledge they were true and correct?
NEE interrogatories 12-1 through 12-4. I did that, dated 24th of May 2021.
And can you just scroll through and see that, in fact, you answered New Energy Economy 12-1 through 12-4?
Yeah, 12-1, I answered that based on this document. 12-2, I also answered that one. 12-3, I also answered this one. And 12-4, I also answered this one.
Okay, great. And then I have some questions about your rebuttal testimony from July 29th.
July 29th.
I think that's joint exhibit number 8. Joint applicants exhibit number 8.
Yeah, exhibit number 8, yep, July 29th.
Could you please turn to page 2?
Yes.
Here on line 25, you refer to NMSA 1978, section 6218-16J. What is that?
Objection mischaracterizes the testimony. This is demonstrating the language that.
Objection to him to making any comment right now, except for his objection.
Oh, I want to hear the explanation for the objection.
So, Mr. Hearing Examiner, this is a recitation of the stipulation provisions that we would be, or that the joint applicants would be find acceptable. Mr. Zagra is confirming that this language would be acceptable to the joint applicants.
Objection, please. I do not.
What's the objection?
I don't want him to give the answer. I want the witness to give the answer. That's the objection to Mr. Haverly's. What, I don't understand what the objection is. This is his testimony. I'm asking, what is that section referred to?
And I'm
Period.
asking for a description of the objection without providing an answer.
Thank
Sorry,
you.
Mr. Hearing Examiner. What my point was that she said that Ms. Nanasi indicated that Mr. Zagra was talking about that statute, and I was objecting that that's misleading, that he was somehow in his testimony discussing that statute other than to provide a recitation for a stipulation. That was my whole objection, that it was not an accurate question. The premise was not accurate.
Okay, yeah, well, I'll sustain the objection to the form of the question.
Could you please, Mr. Zagra Velasquez, tell me what does NMSA 1978 section 62-18-16J refer to? What is that about?
I think, as I said, to another, question before, from another party, I think Mr. Terry will be the person to explain this, because he has the details of this power plant, and the related matters, with that.
Thank you. Currently, you have agreed to a $65 million increase in the rate credit, and maybe another increase after some discussion with the Water Authority. That rate credit is to be distributed over 3 years. Is that correct? Not 1 year, as the New Mexico Attorney General witness Crane suggested?
The portion of the rate credits, to PNM's customers, which is, rate credits. There are also, as you know, arrearages. There is also, a fund.
I'm sorry, there is also, as you know.
Arrearages. ARRAGES. There is also, funds, for assisting in providing electricity to new customers in remote areas. And there is also, an additional amount for low-income energy efficiency. The piece that I think I understand you're asking is just the one about rate credits. And yes, it will be over a 3-year period following the close of the proposed transaction.
And this is contrary to the recommendation of the Attorney General's witness, Andrea Crane, and Bernalillo County's witness, Maureen Reno, who suggested that a more equitable distribution would be within 1 year and it'd be per customer, not per kilowatt. Is that correct?
If you want me to look at their experts' opinion, I don't know them by heart, but I know this was agreed by those two parties.
So you don't know that there was an objection to the period of time that the rate credit should be distributed?
Maybe there was, but I know, both the Attorney General and the county are now happy with this, proposal. And we have accepted, the revised proposal of the county, and we have, agreed with the Attorney General this stipulation. So from that point of view, I think I'm happy to read if that's the case, what you are saying, but I know that, they have agreed with this, and they have supported, the revised, rebuttal in the testimony, my rebuttal. We have agreed also with the county on this matter.
Why won't you approve a rate credit over 1 year?
This is what we have agreed with the parties, and I think, this is a customary, in most of the transactions that I've seen, is usually the request to split this over time, so it's not just one time off. And I think, customers enjoy over a period of time. That's the reason why, I think usually that happens.
And have you agreed to a rate freeze after the merger if it were approved?
I think there was another party who also in this hearing asked me that question. I think I referred, to Mr. Terry to explain the details why a freeze has not been agreed. And also, I think, the conversations with the parties clearly concluded that they understood, that, rate freeze, was not something, to be considered in the agreement.
Okay, and you have agreed to follow the New Mexico Commission's policies.
Objection misstates the prior statements of the witness.
Sustained.
In your stipulation, you agree to abide by all the rules and regulations of the New Mexico Commission, correct?
That is correct.
Okay. And there was an objection to the distribution of the rate credit not being done per kilowatt hour, but being done per customer. And you have not agreed to that either. Is that right?
Objection vague. And I can explain that if you'd like me to, Mr. Hearing Examiner.
Overruled.
I think if you can point to that motion, I am happy to review that. If that's the case, that's true. And if it's true, I think Mr. Terry will be more than happy to explain the reason behind that.
So you don't know why the decision was made to have a distribution per kilowatt hour usage as opposed to per customer. Is that right?
I think that's something, those details is what the local management takes care of. And they are the ones, proposing and agreeing and implementing.
You have agreed that you will hold ratepayers harmless from any adverse impact of the merger acquisition. Is that correct?
If you can point to that clause, I'd like to confirm that.
Do you not believe that that's what the merger agreement and stipulation do?
I'm sorry, but I have so many things in my mind that if you can just point to that, I'm happy to read that. I want to make sure that every single word that you said is exactly what I see, in the wording.
So
if you
There, yeah, I think it's the second. Mr. Azagra, could you please turn to joint applicants exhibit number 2, which is the filing of the stipulation.
You have 5 minutes, Mr. Nazem.
This one, number 2. Yeah, exhibit number 2, yes. Notice of filing second amendment stipulation.
I'm sorry, sir, if you could say that slower.
Exhibit 2, notice of filing second amended stipulation.
Thank you, sir.
Could you go to page 3, letter G?
Letter G. Yes.
Is it true that the joint applicants agree that the merger will result in fair, just, and reasonable rates and will not adversely and materially be affected by the merger?
Yes, in GC says meets the requirement of Rule 450.10, included that the level of investment appears reasonable and that PNM's ability to provide reasonable and proper utility service at fair, just, and reasonable rates will not adversely and materially affected by the merger of NM Green with PNMR or the transfer of PNMR's stock to networks.
So you believe that there will be no harm as a result. There will be no adverse impact as a result of the merger to ratepayers. Is that correct?
I think the merger from a legal point of view, the implementation of the merger, and also the transfer of the shares, I think that's something that should not affect, to ratepayers.
Okay, and could you look at the next page in the paragraph 3?
Page 4, should I read that?
No, just look at line 3, paragraph 3. The application combined with the stipulation will not result in improper subsidization of non-utility activities and provide adequate protections against harm to ratepayers. Is that correct?
Yes, that is what it says in number 3 of page 4.
So if the merger requires the divestiture of Four Corners, and that will result in a $300 million plus interest, non-bypassable charge on every ratepayer's monthly bill. Isn't that an adverse impact to ratepayers?
Objection, speculation.
Overruled.
I think the merger, sorry, the sale of Four Corners is a decision that has been taken by PNM, unrelated to this, before that this merger negotiations took place, and it's not a transaction cost, and it's not something that the proceeding that is already going happening in a separate case is the one to rule on that. So that's why this merger case is about the merger, and then you have a separate case to rule on that. I'm sure you know that the ruling on that will be according to regulation, and we will have to abide by the ruling in that other case. I think in this merger case, the example that you are giving for me is unrelated to this merger case. It has a separate case to be dealt with.
So are you willing to change the merger agreement to to remove that Four Corners divestiture so that that 6.19, for instance, that Mr. Marks raised with you, so that there is no question that Four Corners divestiture is a transition cost of the merger?
I think it's not a transition cost, it's not a merger cost, and it's unrelated to this merger case. It has a separate case. And I think when companies like PNM and Iberdrola Avangrid sign merger agreements, we comply with them. So we do not amend them. I think that clause was clearly there. It has a purpose, it reflects what they were negotiating, and it's clearly part of the merger agreement.
But sir,
That's Ms. Nanazi, that's your time.
thank you so much.
Staff, you're next. You reserved 20 minutes.
Yes, thank you, Mr. Hearing Examiner. And good afternoon, Mr. Azagra Blazquez. Is that how you pronounce your name?
It's okay, Mr. Warman, that's a good pronunciation.
I'll do my best. You are on Avangrid's board of directors, is that correct?
Yes.
Okay. And as such, you are privy to the strategies being pursued by the Avangrid board of directors?
Do you mind to repeat the question? Because we cannot hear you that well.
Okay. As a member of the board of directors, you are privy to the strategies being pursued by the Avangrid board of directors. Is that correct?
I'm missing one word that you say that I'm sorry, I cannot understand, but yes, I'm in the board. And,
You're aware of what the strategies
yes,
that okay. And one of those strategies involves the acquisition of PNM that is the subject of this hearing, correct?
That is correct.
Okay. What's the relationship between the Avangrid board of directors and the Iberdrola board of directors?
There is, one is the board of a controlled subsidiary, and the other one is the board of the parent company.
Well, let me ask it like this way. Does the Avangrid board report to the Iberdrola board?
No.
Okay, does the Avangrid board have any responsibility to enact or pursue strategies of the Iberdrola board?
No.
Okay. So now do you have, I guess it's Joint Applicants Exhibit 3, that's your direct testimony filed on November 23rd of last year?
Please say it again, what exhibit?
I believe it's Exhibit 3, that's your direct testimony from last year?
Yes, yes.
You've got that?
Yes, I have it here.
Okay. And let me see if I can find the right page here, because I apparently didn't write it down, but you state, oh, I'm not finding it. I wish I could. I'm having a hard time finding the page I wanted all of a sudden, but you have a statement in here, and if you need me to find it, I will try to find it. But you state that Iberdrola companies provide utility services to approximately 32 million points of supply worldwide. Are you familiar with that statement?
Yes, that is correct.
Okay. What's a point of supply?
A point of supply is an expression that, sometimes if you use the word customers, you may get confused because you may end up with what we call unregulated customers, liberalized business. And that's why, points of supply is the actual, distribution network's contact with customers. We may have in some jurisdictions more customers than points of supply. And that's why we think, for networks, explanation of how many customers we have, it's better to use that term. We may have more customers, than points of supply. That's the reason why we always like to refer to points of supply. It will be what you call customers here, because they are not unregulated customers, being done by the utility or the holding company in this state.
Okay. Now, could you turn to page 6 of that exhibit?
Yes.
Okay, and on lines 15 and 16, you state that Iberdrola's mission and purpose is to become the leading multinational company in the energy sector. Do you see that?
Yes.
Okay, and as someone who's on the Avangrid board of directors, is part of your job to attempt to carry out that mission?
Yes, I think the boards, are to deliver the policies that the group, approves. And that's why, each of the, policies that we have, all the boards, we expect, that you are, committed to making sure that all the subsidiaries and all the businesses, they deliver, the policies and the objectives that we have.
Okay, thanks. Could you turn to page 10 of that exhibit? And beginning on line 20, you ask yourself the question, please explain why this transaction is good for Avangrid and PNM. And beginning on the top of the following page, you have a statement that says, for Avangrid, this is a strategic transaction that creates significant regulated utility and renewable energy platform. Avangrid has already made significant renewable energy investments in New Mexico and believes that the proposed transaction will allow New Mexico to consider new efficient integrated alternatives for replacing aging fossil generation with renewable alternatives. Avangrid foresees excellent growth opportunities in the Southwest, including New Mexico. Do you see that?
Yes.
Okay, and that's still your testimony, right?
Yes, that's a direct testimony.
Okay, yes. So now, when you say that this transaction creates significant regulated utility and renewable energy platform, is this an acknowledgement that Avangrid is looking at both the regulated business and at the unregulated renewable development business?
Yes, yeah, I think when you say the word significant, I think, we are becoming a very large utility company, running regulated activities in the US. So we're gonna, add, the transaction is approved in New Mexico, two new utilities to the group, the one in Texas and the one in New Mexico. And at the same time, we are already, a player in New Mexico with almost, around $500 million invested in renewable. And we believe New Mexico has a huge potential, and we want to continue, analyzing those opportunities and beyond that.
Okay. And when you reference excellent growth opportunities here in the Southwest, you're referring at least in part to growth in earnings, are you not?
No, I'm referring there to investments. I think in the case of New Mexico, clearly, it's a state, with the right policy from an environmental point of view, that's going to move into more renewables, and that's what we will be more than happy competing with other players, to try to promote more renewables in the state. I think it's also a growth opportunity in relation with hydrogen. We have presented different projects to the Biden administration. I think New Mexico has a strong potential in hydrogen. We're one of the top players globally right now in different countries with actual activities in hydrogen, not ideas, but actual things happening. I think we also see New Mexico as a potential unrelated to the utility, in terms of transmission opportunities into Mexico. And also, we were very keen on the utility expanding its operations, because there is some additional needs that the utility has ahead of us. So from that point of view, I think there are different growths at the utilities level and outside of the utility, and that's something that we are very comfortable to start working with the different parties in the state.
So based on that answer, though, it sounds like Avangrid is not interested in growth and earnings.
Oh, we definitely, you invest and you need to give the return to your shareholders. But the word growth here is referred to the opportunity for investments. I think, of course, when you invest, you need to have some return. So you get, from the equity investors and the debt holders, the money to be invested. So of course, you need to generate earnings with those investments. I was just saying that, the reason why we are very, very in love with New Mexico, again, for 15 years giving money for nothing, in a chair in the University of New Mexico, but also with $500 million invested in renewables. And now with almost $8 billion, I know you have also the Texas utility there, but, with almost $8 billion enterprise value, around $8 billion enterprise value, is because we believe, it's not just what you have right now. We can help New Mexico to do many more things. And that's something that, we are very comfortable, to work together.
So if investment in New Mexico would result in no growth in earnings, would Avangrid be investing here?
Objection, speculation.
Well, he's telling me that growth in earnings is not a factor that they're looking at. I'm trying to figure out how that is the case here.
Sorry.
Hold on a second. I need to rule on the objection. The objection's overruled. Go ahead and answer the question.
Yes, I don't think I have said that, we don't want to grow in earnings. I think I was answering, what is written down here. And the growth opportunities, I don't think when you make a presentation to investors, you make a presentation to banks, you don't say the growth is in earnings. You actually present growth opportunities in terms of projects. And when you see our capital, capital expenditure plan, our strategic plan for the next 5 years, we say we're investing $75 billion of capital expenditure. Of course, then we need to translate that into how can we affect the accounts of the group, the accounts of Avangrid, the accounts of those publicly traded companies that we have in the group, in order to give a feeling to the investors about how the earnings are going, to evolve. And I think what I was just answering, I didn't say that we don't want growth in earnings. We definitely want growth in earnings. I think if we were not to have growth in earnings, we will have an issue from a market valuation point of view, and we will have an issue accessing equity. So we need to have growth in earnings. That's the best way to make sure we have access to funds and make sure we are safe, from a capital structure point of view. If we were to say we do not want growth in earnings, we're happy to reduce our earnings, I think we will be, collapsing in the share price, and I think that the capital markets will not be accessible for us. We definitely need, growth in earnings. But I was just answering what you mentioned about what are the growth opportunities we see. We love New Mexico. We believe we can break into New Mexico jobs well beyond, what we can do. I think, when you think about renewables, of course, New Mexico could get, 20 players, to be the owners of those renewables. I think we are a different animal. We are, the second, third, or first largest player in renewables in the US or globally. If we are to do business in a state, we are to take decisions beyond that state. So that's why for us, New Mexico, we expect New Mexico welcomes people like us because we will go beyond what New Mexico offers to us. So we expect to do things in New Mexico beyond the businesses that we can deliver in New Mexico.
So I'm trying to follow what you're saying. I mean, it sounds like you're agreeing with me that at least in part, Avangrid's investment here in New Mexico is designed to grow earnings. Is that correct?
Any investment from any company that I know that is publicly traded, any investment, has to translate in earnings, creation and growth. That doesn't happen all the time, and that's why we have, share prices going up and down. But I think, the answer is yes. Of course, we want to invest and make sure, earnings grow.
Okay. Is it fair to say that a good portion of Avangrid's anticipated earnings growth arising from this transaction comes from expanding its investment in unregulated renewable development activities?
It's a combination of things. I think, the accretion that the transaction brings into the projection of the group, as you saw, is very small in the announcement that we did. The accretion means the increase on the earnings expectation that the analysts have, before the transaction is announced and after you put, PNM into the projections that we have. I mean, we said, it will be, low single digit accretion. So actually the amount of earnings growth that we're going to have because of the transaction, is not very material, but it's, positive, which I think is important for the investors. Most of the things that I'm referring here is beyond the current projections that PNM has. So what I'm referring here is beyond that, not, what currently PNM, has in their projections.
Now, I think you've indicated earlier that Avangrid currently has a couple of unregulated renewable development activities in New Mexico. Is that correct?
Yes, it has, already invested in around $500 million in renewables in the state.
Yeah, the La Jolla Wind Farm is one of them, correct?
Yes.
And the El Cabo Wind Farm. Is that a yes for El Cabo?
Yes. Sorry, yes, El Cabo and La Jolla.
Okay. Now, if this transaction approved, does Avangrid anticipate expanding its investment in unregulated renewable development activities in New Mexico?
We would love to do so. Always, of course, with all the conditions that we have put in the stipulation in terms of making sure that there is a fair process and we can compete, and bid as other people will. And the answer is yes. We believe, not only for purposes of New Mexico, but beyond New Mexico. I think, we would love, to continue helping the state not only to reach their goals, but also to benefit from that energy, in relation with other states and countries.
Okay, well, what if this transaction is not approved? If this transaction is rejected by the commission, would Avangrid still be interested in expanding its investment in unregulated renewable development activities in New Mexico?
Yes, I think that's a very good question, Mr. Borman, because I tried to explain that before. I think the difference for us, if we do, businesses like this utility business in a state, is whether we go beyond, those specific opportunities in the state. So let me just give you an example. We are now awarded by the, Biden administration, the first offshore wind project in the U.S. We're going to have to take a lot of decisions in relation to offshore projects. And some people may say, well, New Mexico doesn't have sea. Yes, Glasgow doesn't have sea. They have, a bay, but they don't have the sea in front of them. London doesn't have that. Our control center of all our renewables in Spain is in Toledo. Well, we need to start taking decisions where we're going to put, control centers, engineers, planning, and a lot of activities in relation with the offshore wind business we're going to be doing in the U.S. We already have
all of in relation to the offshore
wind business that we're going to be doing in the U.S. So if we were to do, this transaction, get it approved, we are people that will not only own El Cabo and La Jolla. We will consider New Mexico as, a state where we will do things unrelated to New Mexico, as for example, the offshore business, as for example, to hydrogen. So that's why for us, you're totally correct. I think we will continue looking at New Mexico for a specific, renewable opportunities. But I don't think we will look into New Mexico to go beyond, those assets. As most, if not all, the players in renewables that you have, will do so. I think our track record when we do things in the states is to go beyond those assets we have in the states and make sure those states benefit from other activities that we have in those states and countries. That's the difference with us. And I'm very comfortable, to explain how in many countries, in many states, we have gone beyond that already.
So I'm not quite sure. I understood the answer, so I'm going to try to seek a little bit of clarification here. So you've agreed that certainly if this transaction is approved, Avangrid would expand its investment in unregulated renewable development activities here in New Mexico. I guess it's a question mark. I think you said that you would pursue at least some renewable activity here in New Mexico if the transaction is not approved, but it would not include the sort of activities that are not necessarily related to New Mexico specifically. Is that correct?
That is correct. There will be no reason. It will be just, if we are doing other activities, that's an incentive for us to focus in that state, as we have done in other countries and states.
Okay. But for those activities that would be, I guess, specific to New Mexico, i.e. building a wind farm or building a solar facility or some other renewable facility in the state, would Avangrid still be interested in in pursuing those activities if this transaction is denied?
Yes, the answer is absolutely yes. But it will be a
Okay.
pity that New Mexico misses a very large corporation wanted to do many more things than just owning those assets.
Okay, thanks. I appreciate your time, Mr. Azagra Vasquez. Thank you.
Thank you, Mr. Borman, as always.
Okay, I have a few questions, Mr. Zagra Blasquez. Could you turn to your February 26, 2021 supplemental testimony? It's Joint Applicants Exhibit 4.
Yes, Mr. Hearing Examiner, I have it there.
You have it? Okay. And in particular, there's an exhibit attached to that, exhibit PAB-2, February 6, 2021 supplemental.
Yes.
And it's titled Avangrid Inc. Appointment Procedures for Avangrid Group Companies.
Yes.
Okay, we're looking at the same document then?
Yes.
Okay, as I understand this, this is a document that establishes procedures to appoint members of the boards of directors of companies affiliated with Avangrid Inc. Is that right?
Yes.
Okay, and if you look at number 3 where it says procedures, it looks like there's two paths. There's a path under subparagraph A on the bottom of page 1 of 4, and then there's a path subparagraph B that starts on the bottom of page 2 of 4. Do you see that?
Yes.
Which one of those would apply to the appointment of directors for PNM?
I think, Mr. Camp will be the one to explain this in detail, but let me just give you an explanation so it's clear. Because in one of the previous questions, I was asked about how the directors of the board of directors of the utility will be appointed. And what I explain is what we always do, on a recurrent basis, which is very simple. The board of that subsidiary, so in this case, PNM board, so there is no misunderstanding, they will review, usually through one of their committees, candidates and propose to the board, that those should be the board members, to be appointed, and there will be a call, for a shareholders approval of those candidates. That's the normal way we do things. I think, what happens in these mergers is that at the time of closing, we need to take, a decision in that moment of, let's call it, the first board of directors of the utility, okay? So what we usually do at that time is, we usually call a shareholders vote in which, we appoint the new directors. So I think I would like to make that difference, usually in the first, moment that we have to close a transaction, usually you have the board members of that. And again, the difference here is I'm always referring more to the holding company. In this case, is the utility. But because of what we have agreed in the commitment to the utility, let's forget about the holding company of PNMR. That's not relevant for purposes of what we are discussing right now. In terms of the utility, we are already making commitments that, as of closing, we're going to have a certain board. So we will have, to do a shareholders vote right at the same time of closing. So it's something that happens in a second, that, we will have to appoint the independent directors. We usually will not change the current board members, until later in time, and the current board members of the utility are all management executives right now, if I am correctly, in my memory. So therefore, we will have to take a decision before to be implemented at that time. So our feeling is that usually, we wouldn't have changed anything. We would have kept that board as it is, and over time, we will make changes. As you know, we are an exception, at networks and some of the utilities, that we actually have independence. It's not something new for us. That's extraordinary. I know most of the US utilities, the German utilities, the French utilities, in their control subsidiaries, the only thing you see is management. PNM, they have in their utilities management in those boards. I think we're happy to accommodate. So we will have to take that change and implement at closing. So that's why at closing, we will have to actually have a shareholders vote and propose those independence and potentially some other changes also in the rest of the board members if we think, that should be the case. So that's why that's a little bit different here. We will have to do something at closing, and then later, if there were to be changes, is what I told you before. But I'm sure Mr. Kant, he will explain that also if needed in detail in his interrogatory.
Well, thank you for that answer, but I'm just something simpler. This was attached to your testimony as procedure for appointing board members of Avangrid Group companies. I'm just trying to understand how this document applies to the approval of board members for PNM.
Yep, I think in this one you have two types. In letter A is those Avangrid companies or Avangrid removals are companies designated by Avangrid as head of business, companies, and all other entities in which Avangrid has a direct and indirect stake and which are not held through a head business company. The following steps. So that's usually when you have a direct stake. I think if you go, to letter B, it says with respect to the proposed Avangrid Group appointments or Avangrid Group removals, in which the head business companies have a direct or indirect stake or are companies that the
Sorry, sir.
Yeah, you need to slow down.
Slow down.
Sorry about that. Letter B is where you mention regulated activities, okay? As opposed to the first one that you will see, is that not mentioned. So I'm sure Mr. Khan will explain, but I think the answer to your question is probably we're referring more, to letter B, because it mentions the regulated activities.
What is the meaning of that phrase, head of business companies?
Head of business companies is, we usually have what we call the business units. So networks, okay? Networks is for us, a business unit. Okay, then we have renewables. That's another business unit. And then we have many times, the head of the business, being the chairman of that, holding company. Then under that, you have the utilities. So that's why we usually refer to businesses are networks, which is different from renewables. And we have that in every country, not just the US.
Okay, so as it applies to Avangrid and PNM here, the head of business company would be Avangrid Networks?
The head of the business will be networks. We have a CEO of networks that basically oversees, coordinates, all the networks. But for purposes of the utility, each of the utilities has its own management. The management that takes the decision is not networks. Network behaves as a board that needs, to behave as a board. The management of the utility is the one to take the decisions in each of the utilities.
Right, I'm just trying to understand this document, that's all. So when the document refers to head of business company, that term as it applies to PNM would be Avangrid Networks, is that right?
PNM, initially, in the merger will be under Avangrid, and right after the merger will be under networks. There are two steps. And then it will become another holding company under networks. So that's why it will become another utility within networks, sub-holding company.
But head of business company means Avangrid Networks in this case.
For me, yes, but Mr. Kam, I'm sure, because he was head of networks as well, and he's deputy CEO, I'm sure he will explain in more detail, tomorrow.
All right. And I wanted to ask you about the audit reports that you submitted with your July 27 testimony. Do you have those? In particular, I wanted to ask you about the version that has the English translation. It's Question Exhibit 8. It is, I guess in your terminology, it's JA Confidential Exhibit July 27 SUP PAB-6.
Yes, I have it here.
Okay, and you have the English translation?
Yes, I have the English one in front of me.
Okay. Well, I just want to get some clarity about what this document is. If I look at the first 26 pages, it looks like it's a document that's prepared by Iberdrola. Is that right? First,
Yes, it's our, sorry, Mr. Pearson.
is that right?
Yes, this is, internal audit, September 2019.
Okay. And then starting on page 27 of 219, looks like there are some things that are prepared by PwC or Price Waterhouse. And that would consist of the rest of the document. Is that right?
I don't have that in front of me. Page 20.
27 of 219.
Sorry. This one? Yes, that's the PwC forensic review.
Okay. Is that the entire document? The entire PwC document?
I know it has been filed because, we yesterday your ruling was that it should become public. So I think yes. Yes, this is the document, yes.
Okay. I guess the reason I ask is I don't really see a what looks like a cover page that a company would prepare, in connection with a report like this.
I think this is usually forensic reports that I've seen going this way. So they are very factual, with a lot of tables, and this is the way they usually reflect this. So it's just probably just because those are the ways the forensic reviews are done this way. I've seen this, sometimes.
Okay. Could you turn to page 16 of that document of the 16 of 219?
16. I'm sorry, you're speaking about the PwC document?
No, I'm talking about the first part, I guess. It's one big document, 219 pages. And page 16.
16 it says appendix. Sorry
right.
about that.
Yeah. So that's page 16 is a cover page for appendix 1, right?
Yeah.
But you go to page 17, and there's just a symbol in the middle of the page, right?
Yes.
Where is there some reason why there's not a report there?
I mean, the only thing I can think of is that that's the previous document. For some reason, you have this, it may have an appendix, that document, and happy to review exactly where that is.
Yeah, appendix 1 refers to an IA report, which I assume is internal audit report.
Yes, which is the previous one. So that's why.
Yeah, but it doesn't appear to be included.
I think more than happy to review if there is any appendix or if it's actually the document that you have before. So we can come back to you on that quickly.
Okay. And actually the same thing is true for appendix 2. If you go to page 18 and 19, there's a cover page for an internal audit report for Iberdrola Renewables, but there's no report on following that on page 19.
Yes, I think this should be 2 reports. One is, for, this subsidiary, which is the one that, is affected by all by this topic. And then the first one is the internal audit. Yes, let us come back to you because I have the same thing that you do. So I cannot answer to you because I have the same page.
Okay. And then if you go beyond that to page 25 and page 26.
Same thing.
Yeah, same thing.
Yep. I think on this one, I can see there are policies. So these are documents that probably we filed the PDF, and for whatever reason, it's not printed out here.
And you're willing to provide those?
I'm sure we are.
In English?
I'm sure we do it on an expedite basis if we don't have it already.
Okay, all right,
Anything you need, we will provide to you.
okay.
I'm sorry in the past if we have, sometimes, not answer, questions, or we didn't take the initiative to provide things. I apologize, but, we are a very transparent company. Anything you need, you'll have it in a second.
Okay. Well, those are all the questions I have. I guess I have one more question, and I don't know if it's for you or for your counsel, but I guess, do you have an idea of how soon those could be provided?
Mr. Hearing Examiner, I will get on that immediately and find out where those documents are and how quickly we can get that. I promise you it will be expedited. And if you'd like me to report on it after a short break or tomorrow morning, I can do that without hesitation.
I think tomorrow morning would be fine.
All right, I will do it.
Okay, thank you. Okay, is there any redirect for Mr. Azagra Blazquez?
Great question, Mr. Hearing Examiner. Can I take just a second and look through my notes here?
Yes.
So I think I have one question. No, I have two questions, I think, Mr. Hearing Examiner, if you'll indulge me very quickly.
Go ahead.
Mr. Azagra, when you were asked previously about the rate credits that you were agreeing to additional rate credits in this case in your rebuttal testimony, was that an unlimited amount of rate credits, or were you referring to certain amounts?
I was referring to the amounts that we have agreed, also, updated, with the okay I provided, to the water utility. That is what I think is acceptable for us to be, approved.
Okay. And Mr. Azagra, Mr. Albright asked you a question, I believe it was Mr. Albright, about Ethisphere, and whether there was any fees associated with being a member of that group. And I believe you said you were going to look into that. Have you had a chance to look into that question?
Yes, Ethisphere is the leader in that area, and there is a fee associated, with, the WME application, regardless of whether you receive the designation. Okay, so last year it was $3,000, and it is important to emphasize that the payments are not to receive an award. They are just for them to independently determine award, and the payment is relevant whether the award is obtained or not. And many people pay that and they don't get the award, and you pay for that. They do the review and they decide whether you deserve the award or not.
Mr. Hearing Examiner, I'm just looking through a couple more of my notes, but that may be it. If you just indulge me another minute or two.
Sure. Yes.
Thank you. I think that's all the questions I have, Mr. Hearing Examiner, on redirect.
Okay. All right. Well, thank you, Mr. Azagra Blazquez. It's been a long day. Appreciate your testimony. I'd excuse you entirely, but I think I need to keep you on the line in case any questions come up about the additional material you're going to be providing in terms of those internal audit reports. So, but for now, you're excused, and we'll, I suppose, revisit the question of whether you need to come back. But for now, you're excused. So thank you.
Well, thank you very much, Mr. Hearing Examiner. A pity I cannot be in person. I'm lucky not to, even at least to be in Albuquerque. And, looking forward, to answering any question, always available, anything that we need, please let us know.
Thank you.
Mr.
Thank you very
Hearing Examiner, Mary Ellen Nancy, I wanted to move in subject to the review of joint applicants, New Energy Economy Exhibit 19 and 21, and the revised New Energy Economy Exhibit 18 and 18A and B, revised New Energy Economy 14, revised New Energy Economy 1-D, revised New Energy Economy 5, revised New Energy Economy 23, revised New Energy Economy 4B, revised New Energy Economy 7, revised New Energy Economy 22, revised New Energy Economy 16 and 12.
Okay. So as we discussed, the joint applicants will have an opportunity to review those documents, see if is there any basis to object to their admission. And I don't know, are you able to do that overnight and come back tomorrow with your any objections that you have?
We will do that, Mr. Hearing Examiner. We'll be ready by the morning to address that.
Okay. Okay. Well, we'll do that then tomorrow morning.
Thank you, sir.
Thank you.
Mr. Hearing Examiner Rick Alvidrez, on the topic of the exhibits.
Yes.
Do I understand that NEE is offering these exhibits wholesale? That is all of the questions and answers, or are they just the ones that were used in cross-examination, or just the ones that they previously identified on Monday?
Mr. Nazi?
Well, I would ask that at minimum, all the questions that I asked about that Mr. Azagra Velasquez affirmed, that all the answers and all the questions, interrogatories that and documents that he responded to at this point in those documents.
Well, are the Mr. Alvidrez, are you going to be able to identify what those questions are without having Ms. Nanazi specify them?
I don't think so, Mr. Hearing Examiner. I mean, one thing we can do is look at the hearing transcript, and we do get those, on an expedited basis. We may not be able to do it overnight. It may be on Monday, but we can look and see what was covered based on the rough transcript that Mr. Lee will provide.
Well, we could either do that, or we could have Ms. Nanazi, further specify what she was questions and answers she's asking to admit. Are you able to do that, Ms. Nanazi?
I'm happy to go through each one of those documents and specify all the questions that I believe that, and then tender that to the joint applicants. The specific ones, basically every question that Mr. Velasquez answered in those documents, I'm asking to be admitted. Whether I asked about them or not, at this point, they are a statement by a party opponent under 801. And so I believe that they're admissible.
Well, I think what we need to do is have you, Ms. Nanazi, specify which questions and answers you're asking to be admitted. And then Avangrid and PNM can, deal with that and make their objections if they have any. So can you do that overnight and come back with that tomorrow morning?
Yes.
Okay. All right. So that's how we'll handle those exhibits. It's 4:45. It probably doesn't make sense to start Mr. Kump this afternoon anymore. Does anybody have anything else we need to talk about before we recess for today? Okay, hearing none, we are in recess until 9 a.m. tomorrow morning.
Thank you.